would be Miss Malone at the Three Rivers LP. Miss Malone, could you join us, please? I think I can unmute your mic from here. Ms. Malone, can you hear me?
Yes.
All right, we're going to start here in just a moment. I was hopeful that Meg Bauer from Legal Aid would be here with us this morning. I've not seen her yet. Served by attachment. So let's call that case. No, I gotta wait a minute. It's 8:59. Then we'll advise Ms. Malone of her rights while we wait for Lamp and Key. Diana Lamont is present. Howard Bush is present. For the
There.
company.
There we go.
All right.
You're all set.
This is filed as a demand for non-payment of rent. Rent is $800 per month. At the time of filing, the delinquency was $2,600. Mr. Bush, if I'm understanding your accounting sheet, current arrearage is
That is correct.
$4,362.
Looking for my copy. That is correct.
Your Honor,
Yes,
actually, if you go to the far right-hand side, that is the current amount due. So it's
$2,760.
$930.
Oh, that's all that's due?
Yes,
All right. This property was served by attachment. Is the person still there?
yes, he is, Your Honor.
All right, that's through June.
Correct, Your Honor.
All right, 930 in rent. We got filing
800.
fee of 130, a service fee of 55.40, an attorney fee of 75. Equals 260.40. Plus 930 is 1,190.40.
Excuse me, Your Honor. That 930 does include the 130 court cost. Sorry.
Oh, courts are in it? Oh, all right. Well,
Yeah, sorry.
so 930 is 800. So basically it shows 1 month's rent of June.
Correct, and a late fee of 25, which I did not put in there.
All right, plus 25 late, 825. But you didn't.
I didn't want to interrupt you.
Oh, I'm on my flow with the record shut off. All right, we're in the matter of Lamp and Key Properties versus Taylor Chernovi, file 25864 LT. Howard Bush is here on behalf of the plaintiff, and their manager, Diana Lamont, is here. We've learned through June the defendant owes $800 in rent plus a $25 late fee. Court costs are $260. So let's recalculate that. 825 plus 260 is 1,085. This is a first hearing, and the defendant has not been personally served, only attachment, and it doesn't look like we have a second mailing. So I'm gonna have to continue this for 7 days. So let's take a look at the calendar next week. That would be June 20th. Hopefully it'll be summer by then. We have a full morning. Let's see if Mr. Bush is set to be here anywhere. Don't see it. Let's set it for 10:30. Does that work for you, Mr. Bush?
10:30?
Next
Okay.
Friday? 6/20, 25, 10:30. All right, it looks to me like he's made quite a bit of payment. He's trying to get squared away. Is he receiving assistance from VA or anybody else for payment of his rent?
Your Honor, he is.
Yes.
They're the only ones that has paid. Mr. Cheveroni has only paid $700 the entire time he's lived there.
So are they on board with this or?
No. They've told him he has to move. That's what I was told, that he was told he has to move.
All right. Well, right now, he's only 1 month behind in the rent, but we'll address it further next week. And see where we are at that time. All right, thank you very much.
Okay.
Ms. Lamont, you're good to go. Howard, I don't have you again till 11. I don't know if you got
I
enough
will
stuff.
be back.
Yeah, there you go, there. Yeah, that's. Get the lucky one.
Yeah, no, I'm just saying.
Double. Thought it was yours, I'm like. Well, I'm not standing, I'm actually pointing out the stuff. No, he's not.
Two cases are now called involving Daniel Jenkins. Mr. Jenkins is in the cell and is disorderly, to say the least. He's railing on and screaming and incoherent in an incoherent manner. John West is present, who is his attorney. In 21-37149, the defendant has a motion. Turn your phone off, please. No phones here. Yeah, I can see the screen, man.
No, but
When the screen is on, it
okay.
gets my attention, and then we don't know if it's on or not. And please follow the rules. There's a sign that says, "Don't bring the cell phone inside."
Well, okay.
Okay, thank you. Yes, it's in English for anybody to understand. Thank you. Oh, boy. Okay, so he is charged here with, apparently he was on deferred or unadjudicated probation since 2021 for burglary of a habitation. And now this motion alleges trespassing from an old time. And then number two, the court found true that he failed to report to the probation office back in October of 2021. So that was a hearing that was held on 6/20/23, 2 years ago now. And I guess
Your Honor, it was held in abeyance, I believe, and then there has been another allegation, a new charge arise.
Well, I
So,
see a new indictment
yes,
filed in 25 CR 371, which was filed or handed up by the grand jury on March 26th of this year, alleging that he committed the third-degree felony of harassment of a public servant by apparently spitting on the police officer, which is while the officer was apparently arresting the defendant for something. And so on November of last year, probation office recommended that because of his actions, which indicate possibly serious mental health concerns, that his probation should include some additional conditions to try to help him with his mental condition. So I'm seeing when we were here in May, and this was set for a status hearing today, and it looks like the last event before the previous event was in November. So from probation, what do we know about him right now?
Well, Your Honor, just to remind the court, from July of 24 to October 24, he was actually in the Conroe Behavioral Center. And for treatment and for stabilization, he was released after that. Since then, he's been in and out of custody. He actually has 3 new charges, 1 felony, 2 misdemeanors. All of the
the harassment of public servant is the felony.
is the felony, yes, sir. And then he's got 2 misdemeanors. They're both criminal trespass.
Okay.
They all originate at the same space.
Yes.
Same space. He's been
Yes, sir.
trespassed from his mother's home, and so he continues to go back there, and that's. And as the court has heard, he does have some issues. He refuses to go to when he is out in the community. He does not go to Spindle Top as directed. He
Okay.
is unmedicated.
Well, okay. I see Dr. Rapon had evaluated him back in 2022. Does everybody feel as though it's time for another evaluation
Absolutely.
to get an update on his condition?
Yes.
So that we can determine what direction this should go in. We got a motion to revoke probation that could be moved on if the defendant is competent. But let's find out.
Yeah.
He may not be. If he's not, then obviously treatment is necessary as soon as possible. So we're going to order Dr. Ed Rapon to evaluate the defendant and this one is an ASAP as soon as possible, please. And when we get a result or report, we will order everybody together and determine what direction we should go in. How's that? Any objections to that? Probation and defense, state? All right. So it is done. Thank you. And Langston?
Yes, sir.
What are we doing on Earl Winston?
I don't believe it's present.
All right, let's find out. We call Earl Quincy, cause number 235706, 35706. And Earl Quincy, there is no answer here in the courtroom. I ask the bailiff to call into the hall for Earl Quincy, please. What is his?
There's our fire.
And there is no response to the name called into the hall.
Probably a no bond status.
Defendant has failed to appear. why would we set this for a hearing if there was already a no?
When we appeared on, in March, of this year, he had tested positive for cocaine the week before. You ordered us to do an administrative hearing and MTRP that was done. And that's why I made the statement that I believe that following that third amended MTRP, they're probably up in the bond set.
Yeah, that's correct. There is no bond currently set.
So we have a warrant for him, but why did we reset it for a hearing? It says it was reset on May 19th. It was reset for today. Why did we do that? If on March, we had a warrant for him.
Judge, there is no current warrant. He was released back to probation, which is why he doesn't currently have a bond. The MTRP was held in abeyance. We released him back to probation, so there was no bond that had to be posted. And there is no current warrant, so what probably needs to happen is we need a warrant.
For what reason? His failure to appear today?
That and the third amended MTRP are both valid reasons, Judge.
Okay. Stand by. I don't have a third amended.
It was filed April 21st.
I don't have it in this file. I have a second amended. Is all I have.
Not wrong from it.
But the defendant was ordered to appear today, correct? Is that what we're saying?
Yes,
Okay, he has failed to appear, then a warrant shall be issued for his arrest and no bond is under these circumstances is ordered by the court when he gets picked up, and we will have a hearing on that matter as soon as possible. What else, Langston, do you need? Is that it? Oh,
That's it.
thank you. Let's go to Mr. DeGuerin's case next, please.
We had a judicial review, Judge. Do you want to do that?
I don't,
I have it on my docket for a chart, Ms. Albro.
what time
Did that
did
get
we
me?
ask the lawyers to be ready on Mr. DeGuerin? But
but I'm not sure. I did not set up this hearing, so I would assume 9 o'clock.
see if anybody's in the queue, because I thought, I didn't want them, I don't want everybody waiting on that, but y'all want to do this, Albro? Is that what you're saying? What is the plan on that?
I don't know, Judge, but it's a judicial review. I know about financial matters.
And, Tawania Albro, please?
Thank you, Judge.
And Judge, I'll get a hold of Mr.
Is
Tenant.
that person in custody or in?
She's out.
Hey, Jimmy, do you mind turning the TVs on for me? I'm gonna step in the back and get a
Oh,
hold
you're
of
so
it.
cute thinking I know how to do that.
You just push a button on the remote. It's on your side. It's on your side of the bar, though.
TVs I can do.
We have a hearing here. We need to take up, that just is going to be a few minutes. If everyone will please stand by. Thank you very much for your patience.
There's no response on this Albro.
Yeah, this was,
Okay, hold on.
Yes, sir.
14-20993 is called the state of Texas versus Tawania Albro. And the defendant was setting here from May 19th to today at 9 o'clock. And this is stand by. Is the still on probation?
Yes, sir.
Okay, some probation issues have arisen about
Is this what payments are?
payments.
Yes, sir.
Okay.
Her probation expires in August, Your Honor.
Okay. Well, if she's not here, then all we can do is Is she failed to appear on other regular?
No, sir, and I spoke to her earlier this week and she said she was coming, so. She got in contact with me and tell me that she wasn't gonna come.
Well, let's figure out if something happened.
Yes, sir.
If it's, this is an odd thing, I don't want to just talk over the motion
Yes,
to revoke her probation and she's arrested if she was just unable to be here today.
Yes.
Is that the lady right there?
Yes, that's all.
Oh, okay, ma'am, come on. We missed you.
Good morning.
You relax, take it easy. Catch your breath. All right. Oh, yeah. This is, I think, an issue about finances. Okay, from probation. I think the last memo we had was October of last year, which was a concern that the probation office had since the defendant had been on probation since 2015, and we are coming up on 10 years. And the issue seems to only be right now a matter of fees,
Yeah,
money, financial.
she appeared in November, sir. When she appeared in November, he did an amendment to reduce her fees to $40 a month. And she's made attempts to pay
Okay.
$40 a month, but she's still in arrears.
Okay, or fees continuing to accrue.
Yes,
Okay, is there a reason? Is there any reason why they don't need to be? It's just, we're getting on the latter stages and we obviously have a financial issue and all she's doing is just piling on.
yeah.
If her financial condition is still poor. I don't know. Is it?
Yes, it's still the same. Yes, sir.
The probate, you have an updated you have all updated information to the probation office so they know what the status is. Your income is what, ma'am?
Yes, I'm sorry.
Your income consists of what?
I get 1,200 a month. Well, it went up Social Security. I received Social Security disability. It went up to 1,200. My rent is $1,000. The rest of my utilities, medication. I'm always still owing somebody at the end of the month.
These financials consist of, we do have we have restitution, don't we? Which is always the greatest concern on money here when there are issues. What was the restitution in the?
None, Judge.
There is none? Okay. So we have a fine. What does all this consist of?
The majority of her fees that she owes is tax and provision fees.
This provision?
Tax and provision fees. She's currently being courtesy supervised in Harris County, but her back fees to us is what she's trying to pay.
Which exists in how much?
It's $4,063.
What is suggested we do here? State probation?
Well,
What do you think?
She comes off probation and she should come off probation in August of this year.
Yes, sir.
And we were suggesting that it'd be possible for her to expire on the
Just waive them?
Yes.
Everybody agree with it? Is that all that's holding her up?
Yes, Judge. To be honest, I never saw this lady's name until today, which that's a good thing. That means for the last 5 years that I've been assigned to this court, she's not been an issue.
Okay. All right.
She comply with everything else.
Okay. Well, then let's handle it that way. That's under her financial condition. That's the humane way to do it.
Yes, sir. And I verify her financial situation.
Okay. Well, we're getting near the finish line. Don't stumble.
Thank you.
All right, good. Okay, anything else we need to bring up on this? Okay, good luck, man. Thank you. Yes, ma'am.
We need somebody from our music and dance. Mark's up there.
Yeah.
Mr. Hamble, Daniel Moten.
That was reset.
Yeah.
That's been reset. Okay.
Here, so we need to release him, you know.
Okay,
I don't know why it was reset, but I do see him here.
From my understanding, there was some additional information that needed to be gathered about where the restitution is going from Mr. Moden.
I did get calls about that, Jay.
okay. Right. And this is all an issue about restitution. Is that-
His
You're
scenario
doing
is all about money.
Judge, if I mean, last time we were in court, you were asking about where the restitution was going, why they weren't getting paid within the 2 years. I am doing research. I did call the provisional compensation, the
Do
restitution.
you have an answer?
The
Yeah. You're
restitution
still,
analysis, analyst is not in, he'll be in
Okay.
Monday, and I'll find out then.
okay. What do we want to do then today? Reset this for a week?
Yeah, they still need to complete their research so we can be
Okay,
certain.
we're gonna just reset it a week, so Mr. Moten, so we can get to the bottom of this, but let the people who are doing the figuring, the math, let them do their job. We're gonna reset it for 1 week, Lacey, thank you,
Okay.
or so, to next week. Hopefully that'll be done, okay? Thank you. Let's get to Mr. Walker. And we're having trouble with the.
I can't go to Probation. I ain't gonna go. The guy there, I was like, okay. And he told me, let's go over the $200. Yeah, honestly.
So fees of some sort?
Yeah, the money can start going for the victims, $200.
Yes, sir.
So I paid fine for that $200. So that's fine. I pay that off, then the
Yes, sir.
victim gonna start receiving money.
Okay,
Yes, sir.
okay, good, thanks. Well, the probation office is on that with you, right? Okay, see her.
Judge, I'm Jonathan Landers. It's a pleasure to be here today.
All right, ready?
Ready, but we maybe judge.
Is it necessary?
You're gonna be able to hear the people on Zoom.
Can you hear us yet, Judge?
The issue is we've got this type of meeting going on with everybody who knows how to operate that stuff. We're all in a meeting about newer technology, so we're trying to get one of those folks out.
We're having,
The chief's office is having a meeting about our meeting and all that kind of stuff.
okay, can Mr. Landers and Mr. DeGarren hear? Are they able to hear us?
I can hear you, Judge. Can you hear us?
We're looking to be able to hear them.
We're having
Yeah, Dick
technical difficulties receiving your
It's about to be fixed.
your audio. We can't hear from your end, and we're working on that. And
Sorry.
somebody's here who I think can fix.
Dick DeGarren, can you hear me, Judge?
We can hear him now.
And then Jonathan Landers, Judge, can you hear me?
Yeah, it's on your computer, not here.
That's okay. Well, if everybody gets up here, we can hear. All right.
Okay, well, go here.
So you can hear us now, Judge?
Yes, sir. Yes, right, I can hear you.
I was saying previously, it's a pleasure to meet you, Judge. I think I was before you maybe 10 years ago on a minor issue, but it's good to meet you.
All the lawyers here in this case, as in most cases, in almost all cases, you do me the honors. Thank you for your professionalism. That's all we should. All right, let's get into this hearing on Mr. Walker as the state is present. Mr. Walker is present, and Mr. Landers and Mr. DeGarren are also present. And this is one of these just kind of a maintenance hearing. We want to make sure everything is being done as the court wishes or intended in this proceeding. I received some information, first of all, that Mr. Walker, you are making some financial reimbursement to the ISD. I've heard $1,000, I think, has been actually paid.
It's gonna be paid on Monday.
On Monday, okay. Good, very good. And how often will restitution be payable? Is it on a monthly basis?
Correct.
You're going to be, okay. And I presume you're still hunting and fishing for some more income to be able to pay back toward this restitution owed to BISD.
And Judge, I'll update you. I verified this. I think your probation officers there verified it as well. Mr. Walker has obtained a job. I assume it's going to be ongoing. I'm forgetting the name of the company right now, to be frank, but there is a letter that's been provided to everybody. So we think he'll be, he is currently working. He has this new job. He'll continue to work, and we're hoping to make payments for restitution while this appeal is pending.
It is also the plan with this job, restitution will increase.
I don't know how much he's getting paid, quite frankly, Judge. I know that he provided probation with a copy of his first paycheck, and it's going to be deposited, I think deposited today, and then restitution paid Monday out of that check.
Yeah, I'm a little fuzzy about this. Is it a set income?
Yes.
You X amount of hours a week or something?
Yes.
Okay. It does, and I mean, is it full-time employment?
It's part-time employment.
Part-time. Okay. Well,
Because of my social security, I can't get full-time.
say that again.
Due to me being on social security, I can't get full-time employment, it has to be part-time.
I don't understand that. I'm on Social Security. Am I making too much money?
Judge, I'm too young to answer that question. I don't know how it works.
Oh, I don't know. I need to look into that. But are you stating that you only a limited amount of time you can spend on income for income purposes, or it affects your Social Security income? Okay, I don't. Oh, can y'all look into that, please?
I'll try and I'll talk to Mr. Walker and try and figure that out. I just know about the time that the age you retire at, I know affects it, but I'll look into that, see what I can do, Judge.
Thank you. Another thing I wanted to ask about is, or get everything straight, is this court's orders. These orders were you're going to be required to stay in Jefferson County unless otherwise authorized, and you are authorized to leave Jefferson County with the court's permission for job purposes. You can leave your home for medical purposes, for food, for church, and that's in the most direct routes to and from your home. But you will stay at home and within Jefferson County, but be allowed to spend all your time you can in seeking income, so that the Beaumont Independent School District can receive as much of its excess of multi-million-dollar loss that it received in this case, that this court has ordered as restitution. This is the same or similar type of conditions that are set for people who what we call placed on home confinement. I give some don't have allowances like I'm giving you, but I want this is clear. It couldn't have been clear. You can leave your home, but for those purposes, food, church, medical purposes, and work in the most direct routes to and from your home. But you must stay at home when you're not doing that. Do you understand? That's the order of the court. And again, the court's emphasis is This is all surrounding.
And there was a payment of $7.90 Looks like that was paid on June 7th. And so there was a June late fee of $55 that was charged as well on the rollover balance.
Got it.
And I'm on a fixed income. I can't pay.
Okay, all
Other
right,
than what
Ms.
I
Cummings, Ms.
Yeah.
Cummings.
Yeah.
If you had to get this paid, how do you think you can get it paid?
$1 down, $1 a month. I'm on a
Pardon?
straight up fixed income, Judge Simmons. I don't have extra money. And
Ma'am,
I'm raising a
ma'am,
grandchild.
Ms. Cummings,
Yes.
Ms. Cummings,
Yes.
I hear you,
Okay.
okay? The reason I was asking the questions that I was asking is because if I didn't think that you owed it, I would say so. But it sounds like it's owed. So the question becomes, and that the case was properly initiated. So then the question becomes, for me, as to how you can get this paid.
I have to pay a little bit at a time. I don't have money.
Pardon?
Your Honor, if the court wants to set this over for the next date, I can certainly talk to my client and see if they're able to work out any sort of payment plan with Ms. Cummings with respect to the balance. I don't have any authority to do that today, but I can certainly inquire with
Okay.
my client.
All right, you understand that, Ms. Cummings?
I sure do.
All right, so here's what I'm gonna do, Ms. Cummings. Is I'm gonna adjourn this to June 27th, 2025 at 1 p.m. Okay?
Okay.
In the interim, Ms. Dornbush is gonna talk to her client, see if there can be a payment plan to try to make this manageable for you. It's just that you ended up with the court cost, and that's really what the problem is here. So we could figure this out. Don't lose hope. We'll get it done, okay?
Okay.
All right, we'll see you. That's an in-person
I got a
hearing on that.
question.
Yes,
Do
ma'am.
they keep adding late charges when you don't pay? So does it stop here?
Okay, all right,
What?
Ms. Cummings, Ms.
Yes.
Cummings,
Yes.
hang on. We'll figure that piece out for any late fees that come later in the month. But let's try to figure out if this were the amount, how we're gonna get that paid. And let's try to work out a payment plan, and then we'll figure out the late fee part after that, okay? So let's take it one step at a time, all right?
All right. Okay.
Okay?
Okay.
So I'll set it out on the 27th at 1 p.m. That's an in-person hearing. Okay, Ms. Cummings?
I'll be here. I'll be there.
All right. Thank you, ma'am.
Thank you.
Arbor Woods versus Heather Randall.
I'm here.
Oh, there she is. All right. All right. What is the plaintiff's claim in this case?
With cost, Your Honor, $3,889.75.
Okay, Ms. Randall, how are you intending on getting that paid?
I just got back to work. I've been in the hospital. I had surgery and then had to subsequently go back in. So I'm back to work starting Monday full time. So 2 weeks from then, I can make a payment of at least $1,200, and then I'll have to see, the dates on the rest so I can figure out. I do get paid weekly.
Okay. All right. So hold on there for a moment. When's the next time you think you can make a payment of at least $1,200?
Next Friday.
On the 20th?
Yes.
Okay.
Well, it would be
So-
Saturday.
Right, gotcha. So and by the 27th, can you make another payment or no? If
Yes.
you get paid weekly.
Yes,
All
I
right,
get paid
and
weekly.
how much would that be, you think?
600?
600? All right.
Yes.
Okay, so here's what I'll do. Have you reached out for assistance at all, ma'am?
Like I said, I just got out of the hospital, and I just got all of this paperwork. So I will be filing, for a state emergency relief and looking into other things, looking into other
Okay.
avenues.
All right, let's do this then. You look at making those payments. I will adjourn this to June 27th, 2025 at 1 p.m. And then what I'm going to do, did you see the video and do you have the numbers and things like that, or?
Yes, I saw the video.
Okay, so what we'll do is let me also, since you just got out and to try to make sure things stay on track, you still make those payments. I'm going to put you into a breakout room with our court liaison officer.
Okay.
And talk about what might be available for you, okay?
Okay, thank
Try
you
to
so
get you
much.
back on track.
Thank you.
Okay? All right, we'll see you in a couple weeks. Thank
Thank
you.
you.
Court calls the case of Arbor Woods versus, you're gonna put her in the thing? Okay. Court calls the case of Arbor Woods versus Erwin, Ulren, excuse me, Robertson.
And that's a dismissal, Your Honor.
That's you made me stumble over the name and then, okay, that's okay.
Sorry.
All right, that case is dismissed without prejudice. Arbor Woods versus Damon Stafford. And also Banseri Polk. Stafford, Polk, not here, you may proceed.
Thank you, Your Honor. Mr. Stafford did reach out to our office this morning, Your Honor. He indicated that he thought court was yesterday and that he is traveling today. He indicated he was going to try to get onto the Zoom call today, but he didn't specifically know when his plane was departing or if that would interfere. I let him know that if he wasn't able to sign onto Zoom, I'd have to request the default judgment. He indicated, Your Honor, his intent to have everything paid on June 25th. The statutory 10-day period is June 23rd, and I let him know that. And I did also let him know that he could reach out to Arbor Woods directly to see if they would hold off on seeking the writ until after June 25th.
Okay.
So for that, I do have to request the default judgment, and there is rent to retain of $1,483.73, costs of $242 for a total of $1,725.73.
What I'm going to do in this case, and thank you for informing the court in your candor, I'm going to grant a judgment for possession to the plaintiff with the redemption amount in the amount requested. I will do this since they reached out and he indicated a specific date, and I don't think it's going to cause any harm. A writ to issue the 25th. I'll do it that way, and I realize I'm doing that over the objection of plaintiff.
Thank you, Your Honor.
Thank you. Court does call the case of Arbor Woods versus Carol Toronto and Judith Wells.
Say here. Oh, I'm here.
Okay, hello, Ms. Wells. All right. What is plaintiff's claim?
With cost, Your Honor, $3,481.44.
All right. Ms. Wells?
Your Honor, if I would be allowed to speak for Miss Welts, I'm Carol Taranto's daughter.
I'm sorry?
I'm Allison Kirby. Sorry. I was wondering if I would be allowed to speak for Miss Welts and Carol Taranto. I'm their daughter and granddaughter, respectively.
Okay. So you're the daughter and
I'm Carol
granddaughter.
Taranto's daughter and Judy Welts' granddaughter. Yes.
Okay. Okay. Normally Go, I'll let you go ahead. All right, what did you want to say?
Thank you. I really appreciate that, Your Honor. I would like to request a motion for continuance. If possible, Carol Taranto is the primary provider and therefore has more of an idea of the finances, but she's currently in the hospital. So I was hoping if we could push this case until she was released.
All right. So let me ask this before I do anything. Is there any amount that can be paid within the next couple weeks? Do you know?
I don't currently know the state of her finances, unless that was something that I would be paying, but yes, that I'm unaware of that. I'm sorry.
All right, Ms. Wells, you don't have any idea as to whether something can be paid or not?
No, I don't know, Your Honor.
Okay. Okay. Here's what I'll do. I will adjourn the matter to the 27th, 2025 at 1 p.m. That's an in-person proceeding. Are they going to potentially be in need of any assistance, ma'am, do you think, or?
I'm sorry, I'm sitting with Judith here. We are currently having a very hard time.
Who are you?
I'm sorry.
I'm sorry.
I'm so sorry. I'm just helping Judith in person. My name is Anna. I'm one of her granddaughters.
Okay, so I got granddaughters and all over the place here. All right, go ahead.
Yeah, sorry. One has been coordinating getting the hospital to like fax documents over, I guess, and then I'm the one that is in person with Judith.
Okay.
But I am seeking resources for her for all of the above, like any type of state assistance, anything that we can be directed to, we would appreciate.
All right. So here's if they seek assistance through DHHS or anything along those lines, or any other type of assistance, in the packet, there is what's called the rental assistance form, the packet that was served on them. That would need to be filled out with, and if it's DHHS or a state emergency relief, there's a tracking number that would have to be put on that form. All right. If there's any other type of assistance, that would have to be listed out. And then that form needs to be filed with the court by Wednesday. Okay.
Oh, I'm sorry.
Okay, I got it, Grandma.
Okay.
You got that? Okay. And here's what I will do also. She's just going to be busy today. Let me have the two things here. It will put you in with my court liaison officer, and they may be able to apprise you of other assistance that might be available. Okay?
Yep.
Thank you so much, Your Honor.
Thank you. So that's on the 27th. That's an in-person hearing. All right. But we'll go from there on that. All right.
Thank you,
Yes,
Your
hold
Honor.
on. Pardon? Who's the last name?
The one with Judith Wells, the granddaughter.
Oh, the granddaughter that's with Judith Wells. For our records, we need your last name.
Jones.
I told you it was really easy. No, I'm kidding. All right. All right. Well, so you guys hang on the line. We'll put you into a breakout room with Amy, and she'll be able to discuss some things with you. Okay?
Yes, thank you so much, Your Honor.
Yes.
Thank you. Arbor Woods versus Roy Williams.
There's a second tenant.
Oh, I'm sorry. And Terry Williams. Roy or Terry Williams, not here. You may proceed.
Thank you, Your Honor. There's rent to retain of $785.24. Cost of $242 for a total due of $1,027.27. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff. That is by default for possession, redemption amount, in the amount requested, writ to issue with 10 days. Northfield Estates versus Emma Lowe.
Hello,
Hello, Miss Lowe. How are you?
I'm okay. How are you?
I think I'm okay. All right.
I feel
And
excited.
what
I've
is-
seen you on court cam before. I feel like I'm talking to a celebrity.
Yes, Miss Dornbush is a celebrity. All right. All right. What is plaintiff's claim in this case?
With costs, Your Honor, $1,438.65.
All right. All right. Ms. Lowe, how are you intending on getting that paid?
I just got my first paycheck at my new job today, so I was gonna pay 800 of that, and then before my next paycheck should be able to come up with the rest of that balance.
Okay, so you're gonna pay 800 today?
Yep.
Okay.
And
Your then Honor,
just to clarify, my client reported that Miss Lowe already paid 800 today. So is she going to pay another 800 then?
Correct. This was my first paycheck at my new job. I lost 2 jobs in 3 months, but I have 2 new jobs. So I'm hustling, trying to get that money paid.
Gotcha. Okay. I just wanted to clarify, Miss Lowe, because I knew you had made the one. So.
Okay,
Yep.
so you already paid the 800.
I paid an 800 this morning. I have another 800 coming tonight.
Okay, so there's gonna be a total of 1,600 that's paid.
By Monday, when they get the after hours.
Okay. All right, so if you do that, what will likely happen, I'll give you an adjourn date of the 27th, 2025 at 1 p.m. But that will look like that will take care of everything. And so that if that's paid, the case would be dismissed, or am I wrong?
Nope, the 1438.65, Your Honor, already takes into account the $800 payment made this morning.
I got you. That makes sense. I'm sorry. Okay. So you're gonna pay the 800. I'll adjourn it out to the 27th at 1 p.m.
If I have that balance.
Make that,
Thank you,
okay.
sir.
And so when's your next check?
It's 2 weeks from today.
So on the 27th?
Yep.
Okay, so do you think you can get something paid if it's gonna be the balance before, say, noon on that day?
If it's paid total by balance, does that mean I don't have to show up in person?
What, you don't want to be there in the presence of a celebrity?
I
What's the
do, but
deal?
I just
No.
don't want to miss any more work. Just starting at my new job.
Ma'am, if everything gets paid prior to the court date, they would dismiss it.
Oh, thank goodness. Thank you so much. Yes,
All
that will
right.
be done.
So, all right, then I'll set it on the 27th at 1 o'clock. Ms. Lowe, you have
Thank
a
you
great
so
weekend.
much. You too.
All right, take care.
Bye.
All right, that's all I have for you, Ms. Dornbush.
I agree, Your Honor. There are a couple people though signed into Zoom. I don't
know.
if they're Arbor Woods tenants. They might be dismissals, but before I signed off, I just wanted to make sure I wasn't missing anything.
And they all disappeared except the phone, but I don't have the number.
Yeah.
There is an individual who has called in. I don't have the number up anymore.
Hi. Hello.
Hello, what's your name?
Kimberly Fleischman.
That one is a dismissal, Your Honor.
That was a dismissal? Okay. Your case has been dismissed, ma'am.
Okay, thank you. Have a good morning.
All right, you too. Thank you.
Thank you.
And I don't have anybody else on there, Ms. Dornbush.
Nope.
Timestamp of when she identified herself on the video at 9:03 a.m. Is when she's approaching the hostess stand and the
So she's got my.
Could do. I got to get a few things on the record before we get into the substance, but I appreciate everyone's perseverance in this case. And you're welcome to be you're welcome to stand at the podium. You also can be seated and just have the microphone in front of you. Is your comfort level. Great. Okay.
Is Michelle Hansberry our court reporter?
Nope, there's a court reporter sitting right here. Michelle Hansberry is my judicial assistant, and she will not be taking the hearing down.
Okay, I just need to make sure that I guess the court reporter's got the pleadings, so she's got my email, so she can send me
Right, and we'll get all that on the record. I'm just
She's here. Triple check that.
yeah. She was here early. I had to come out to court to grab something around 9, and I wasn't even in court clothes. Her eyes got real wide, like, who are you? Like, same guy, just not wearing the dress. Okay, I think we are all set. Madam Court Reporter, are you all set? Okay, well, let's get on the record. This is 2023 CV 384617. It's Ms. Marquez Adame versus Big Wake. I'm Judge McBurney. I am in courtroom 8D right now. If I could have the appearance for Ms. Marquez Adame.
Wick Cawthorn for plaintiff.
And am I pronouncing her name correctly, or should I say it different?
Yes, sir, that's correct.
All right, got it. And on behalf of Big Wake.
Sam Wharton.
Ms. Wharton, you filed it was sort of change of counsel for Big Wake that was confusingly worded because it said that you're sort of joining the team, but then it said you're not on the team. I trust you are the designated representative. I know Ms. Christie is sort of lead, but you're here. And I just want to make sure there wasn't something funky about what's going on at your firm's side.
No, it was just the prior lawyer that argued this motion back in October is no longer with our office.
Okay.
So I just wanted to make it clear, she's no longer with us. I'm appearing instead of her, and I just wanted to make sure nothing got sent to her about rescheduling this.
Okay.
So no.
All right. So I think what happened in your notice is that you put your name in one too many places, and where it should have listed the name of the person who's not with the firm, it listed you again because it said you're on it, and then it said you're off it. Don't send anything to Ms. Wharton. But then you signed it, so I figured it's all good. You're here. That's the important part.
I did not want anything to go to her because that keeps happening, and so
Okay.
when in all of those cases, I went and put my name to hopefully avoid that happening.
Got it. Okay. Let me start with this, and it's an apology. It's an apology to the lawyers, and in particular to Ms. Marquez Adame, who has been waiting now. We're on year 7 almost for closure on this. Whatever closure is going to be, it may be disappointing closure for her, but closure nonetheless. Part of the age of the case, I guess, is because there was a refiling. So this is a second round at the lawsuit. But there is a big piece of the delay that lands at the feet of the court. This was a case, it's always been assigned to me, the reincarnation of it. But when we had the benefit of some additional resources because of COVID funding, I asked a senior judge to hear the motion for summary judgment. It was through what we call Project Orca. Don't ask why it has that name. It was the very last thing that Judge Brantley heard. It was the last one that got submitted. I don't know if it was the last that got submitted, but it was the last he heard. And we did a bad job of ensuring, as the Orca funding and staffing was phasing out, that they finished what they had. And so this is a motion that has already been argued in front of another judge. And he apparently had some thoughts about it, but the staff attorney who was there to support him isn't here anymore and was let go, not because of performance issues, but she was a term employee, and that term ended before Judge Brantley and that staff attorney had connected and worked through this. And that took me a while to figure out. I assumed because we submitted it to Orca that they wouldn't leave it half done. And so I was moving happily along to other cases. And then my staff attorney figured out, wait, there's no order on the motion for summary judgment. So we're looking, why do we have a 2023 case still rattling around? Not the fault of any of the attorneys involved. It was a court side error. And then regrettably, when I reached out to Judge Brantley just a couple months ago, having figured out where we were, he said, I'm not able to recollect one way or the other. That would have been information he passed on to the staff attorney, who would have done a draft of an order, and that never happened. I read your briefs every which way and reached out to both sides saying, I'm happy to rule on the pleadings. But at least one of you, if not both of you, said, no, I want a hearing. And it just takes one side to say we want a hearing. And so we're having to do it again. And that's the basis of the apology. That's expensive to you all. It's inefficient for the court system. But I made sure I read everything extra close. I try to read everything in any motion for summary judgment, just so that we can spend less time together today and you can focus on the high points of your arguments. And then I can commit to getting an order out or asking one of the two sides to do a draft of an order based on what I think the right outcome is. So hopefully you accept the apology on behalf of the Fulton court system, not how these things should work. Orca did some great work. I had a number of cases resolved through that. And it just was being last in line meant that they just didn't quite wrap it up. Pivoting to this case, my understanding is that this was a slip and fall at a Chick-fil-A. Ms. Marquez Adame was coming into the Chick-fil-A with two relatives, and it was in October of 2018. She slipped on some liquid. She says she didn't see it. We have a Chick-fil-A employee who just a couple minutes before had done a round to make sure things were safe and clean. And so a lot of the debate is about, did Big Wake really have superior knowledge of this hazard? If there was a hazard, there've been a bunch of depositions. I got the sense from looking at some of the depositions and the excerpts therefrom that there probably were some language barriers in some of the exchanges because there were good questions asked and the answers sometimes were a little disconnected. And I suspect that's because the effort to respond across a linguistic barrier led to some confusing answers. And that's not anyone's fault. It just makes the record a little muddier because where you would expect the answer to be, yes, I saw the puddle. It's my sister slipped and there was a green liquid. And so it's semi-responsive, but it doesn't connect entirely. I also know that some of the things that, or I'm recalling, that plaintiff points to is that I'm blanking on her name, but the woman who was responsible for making sure that the area that Ms. Marquez Adame was traversing was clean and safe, had a little before the 2 minutes before she had done that. I think her shift hadn't started yet and she was drinking something from a tumbler. And at one point on a video, she's seen like brushing her pants off or something. And so plaintiff points to that as, see, she must have spilled and she was cleaning herself off and maybe that's what's on the ground. And so I'm here today to listen to all those arguments, but I want you to know that you're not starting from scratch, even though it's a new judge and a new courtroom. I immerse myself in it as best I could so that you'll get immediate traction as opposed to me saying, all right, well, tell me why we're here. Is this a criminal case or a civil case? I know generally why we're around. So I'm going to ask Ms. Wharton to start. And then when you're done, we'll hear from Mr. Cawthorn and then Ms. Wharton as the movant. I'll let you wrap up. Okay?
Thank you so much, Judge. Yes, Stan Morgan here for the Movement Big Wake LLC this morning. Good morning. You're correct, Judge. This case involves a slip and fall that occurred at a Chick-fil-A branded restaurant that's owned and operated by Big Wake on the morning of October 22nd, 2018.
Remind me where the Chick-fil-A is.
I believe it was in Austell, Georgia.
Fairburn.
We're here because Big Wake is a Fulton County corporation.
It's Fairburn.
Okay, so the slip and fall was in fact in Fulton County also. Okay, got it.
So plaintiff, her sister Maria Marquez, and then a friend, Petrus Cardenas, I'm not sure if I'm pronouncing that correctly, arrived at the store that morning. We have objective surveillance video footage that shows that just 2 minutes before the fall, Big Wake employee and dining room host Keisha Neal walked through
Miss Neal. How do you spell that?
Neal.
Great. That's the person I've been talking about with the tumbler and she's wiping her pants down. Okay.
So there's objective surveillance video evidence that shows that Miss Neal walked through the exact area where plaintiff would fall just about 2 minutes later. She testified that she inspected the area before as she walked through and that she found no substance on the floor during her inspection, just 2 minutes before.
But is either the sister or the friend say, when I was kneeling down to help my sister up, there was a liquid on the ground?
Yes, so when they arrived in the restaurant, they got in line.
All right.
We're hearing case caption State of Ohio versus Kenneth Barton, case number 25 CR 0000673. In this matter, on May 16th, there was a secret indictment filed, 4 counts, that being making false alarms, a felony of the 3rd degree in violation of 2917.32A1. Count 2, inducing panic, felony of the 4th degree in violation of 2917.31A1. Count 3, making false alarms, felony of the 3rd degree in violation of 2917.32A1. And count 4, attempted inducing panic, felony of the 5th degree in violation of 2923.02 and 2917.31A1. We were set today for purposes of arraignment. It's the state's understanding that the defendant has been served with the indictment, so we are here today for purposes of setting bond. The defendant is present with his counsel today, Mr. James Matthews.
Mr. Matthews.
Thank you, Your Honor. Mr. Barton would waive the reading of the indictment, any defects in service, and enter a plea of not guilty to all charges.
Not guilty plea will be entered as the bond.
Thank you, Your Honor. The bond that is being recommended by the state, $50,000, is beyond the reach of Mr. Barton. He is asking the court to consider a $5,000 10% bond, or at most a $10,000 10% bond. He is currently on transitional control and is set to be released from prison Monday, the 16th. He has been in the community since January of this year. He's been working at La Malfa and residing at Harbor Lights, where he has been complying with all rules of that facility, passing all of their drug screens, and he is taking Supplicate, which obviously the use of drugs, probably a highly motivating factor in many of his offenses over the years. But with the Supplicate, he has got that issue under control and is asking that the court consider a bond he can make so that he may remain in the community.
Ms. Linden.
Thank you, Your Honor. Your Honor, in this case, part of the issue is the fact that the defendant called in a bomb threat to the adult probation department saying, in 25 minutes or later, you guys can decide. Basically, karma's a bitch, saying that the whole probation floor was going to be blown up, and said some other things that caused a significant amount of concern to the probation department. And after he did that, then he failed to report. He has a history going back to 2010. He ended up having a domestic violence in 2010, a domestic violence in 2011, an assault in 2013, burglary F3 in 2013, and as part of that, being placed on community control and being an IOP, he had a probation violation and then a second probation violation where he was discharged from aftercare and he had a positive screen, and then his third probation violation on that was that he stopped reporting. He ended up going to prison for 35 months, was released in May of 2019, and in 2013 he had also had a possession of criminal tools and a petty theft, as well as an additional theft. Then in 2017 an aggravated menacing, in 2019 another assault, in 2020 a theft where he went to prison, was released in October of 2021, and then shortly thereafter in 2022, counterfeiting with Judge Condon. He was placed on community control, did jail treatment, but then he had a violation for bringing in someone else's urine, having a positive marijuana screen, and again, failing to report to probation. And so I understand that he's on the transitional control at this point in time, but due to the nature and circumstances of this offense, due to the fact that he called in a bomb threat and then he's failed to report, and here called in a bomb threat and then failed to report, he's a significant risk to the community. He is a risk of flight, especially in terms of the nature of the charges and the fact that he's failed to report in the past. So we believe that 50,000 cash or surety or 10% is an appropriate bond, and we'd ask that you set that.
All right, bond will be set at $10,000 cash or surety or 10%.
Thank you, Your Honor.
Thank you, Your Honor. Your Honor, we're here now in case captioned State of Ohio versus Jesse Ramey, case number 25 CR 000562. And this matter of 4-count indictment was filed on June 2nd of this year, alleging 1 count of aggravated vehicular assault, a felony of the 3rd degree in violation of 2903.08A1A. Count 2, aggravated vehicular assault, felony of the 3rd degree in violation of 2903.08A1A. Count 3, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a misdemeanor of the 1st degree in violation of 4511-19A1A, and then operating a vehicle under the influence of alcohol, another misdemeanor of the 1st degree, but in violation of 4511-19A1D. The case was set today for purposes of arraignment. Defendant is present with his counsel, Mr. Noah Munier, say it correctly, and we are here for purposes of setting the bond.
All right, Mr. Munier.
Thank you, Your Honor. Attorney Noah Munier, standing in for Attorney Don Malarse for purposes of today. Judge received a copy of the indictment, waive reading open court, waive defects in time, manner, and service, explanation of rights and penalties, and her plea of not guilty as be heard regarding bond.
All right, not guilty plea will be entered as the bond.
Thank you, Your Honor. Judge, my client's been in custody for 55 days. We have executed a speedy trial waiver and filled out the bond paper, assuming the court's going to grant some bond. Judge, I know the bond, I guess there was a no bond issue coming over from municipal court. My understanding is that was regarding the possibility of additional heavier charges coming based on this lady's health. My understanding is she's been released from the hospital at this point. Judge, my client has 1 prior OBI in 2019. That's his entire criminal record. The only time he's ever been in front of a judge. He did do the 3-day class because his car was totaled in this matter. He has no transport. He won't be driving if the court lets him out. In the back of the courtroom is his father and his 2 aunts here to support him. He is fully employed, working at a printing press at Kennedy Group Printing Press for the last 10 years. He is a lifelong resident of Lake County and will obviously appear back in court. He has retained counsel and he has spoken to his employer. And even though he's been gone for almost 2 months, they are willing to take him back. He is a good employee for them. Based on that, Your Honor, I'd ask the court to set a low cash bond, allow his parents to post, his father to post, allow him to return to work while this case pens. And again, we have executed the speedy trial waiver.
All right, Ms. Linden.
Thank you, Your Honor. Your Honor, at the municipal court level, no bond was set, and there was a reason for that. And we are asking again for a no bond hearing. And in this particular case, Trooper Pugh is here in case we need to actually put some additional testimony on the record. This case stems from an incident that happened on April 19th around 2:30 in the morning in Madison Township. There was a serious injury crash on I-90. The defendant and another vehicle were traveling westbound on Interstate Route 90. The defendant actually rear-ended the victim's car. The victim's car flipped and rolled twice into the median and grass area between the eastbound and westbound lanes, and the defendant's car then traveled off and struck a tree. When Trooper arrived on scene, the defendant actually smelled of alcohol. His eyes were bloodshot and glassy. It was slurred speech at that time. He had said that he had 2 beers in the last 3 hours prior to the crash. When they did the standard field sobriety test, basically every clue was present there. And when we looked at what happened to the victim here, in addition to the .159 BAC for the defendant, there are some additional medical records that they're still waiting for. I know that we have received some that will be provided, but according to the family, she was in rehabilitation hospital in Akron. She had 9 broken ribs, a broken femur, broken nose, right hand, wrist, elbow. Her lungs were punctured. She had a lacerated spleen. When I spoke to the trooper, she was actually in and out of a coma at the time that this happened, had multiple concussions. And in terms of the surgery, she's had multiple surgeries as a result of it as well. The defendant does have a prior OVI in 2019. Here, when we're looking at the nature and circumstances under 2937.222, we have to look at the nature and circumstances of the offense, whether it's an offense of violence or involves alcohol or drug abuse. Here, in fact, it is a felony OVI case while he's driving while impaired involving alcohol and caused significant and serious physical harm to the victim in this matter. We also have to look at the weight of the evidence against the accused. Weight of the evidence here is he's the only person in the vehicle when police arrived. He admitted to driving. He blamed some of the driving on the victim, driving only 40 miles per hour. Victim said she was not driving 40 miles per hour and was not even in the fast lane. And here, in looking at the fact that the defendant does live in the area, but looking at his history related to the prior OVI and being placed on probation at that point in time, looking at his ties to the community and then looking at his danger of the community, the danger of the community is far outweighed by any ties he may have to the community. Now we believe that the no bond was in fact appropriate at the time that it was set, and we are asking that the no bond be set again, and if a hearing is necessary, then certainly we have trooper for you here to do that.
All right, I'm going to set the bond at $150,000 cash or surety or 10%, implementation of a scram unit, no driving and no contact with the victim. Anything further?
No, Your Honor.
Thank you.
Or beginning problem. I think those need to be at the highest level. Is this your report, Ms. Officer Lars?
It is not, Your Honor. I did not do the PSI. I was just assigned for the testing. It would be Officer Green. Your Honor, if I may, I did go back through and I looked at Mr. Ganash's testing. From the date you signed him up from testing back on May 3rd of this year, or I'm sorry, March 27th of this year, he has only had 7 days where he has not tested positive for cocaine.
That's why this score is it says a 1, and 1 is a no problem or beginning problem. And like I say, that's completely wrong if the allegations are true. And I think he admitted at the last hearings that he was using the new allegations. There's still allegations that I don't have an admission from him, but it's likely that he's probably it's probably true as well. Attorney Warfield, good morning to you. Can you put your appearance on the record for Mr. Ganache?
Good morning, Your Honor. Attorney Jessica Warfield, P85391, Specialty Court Counsel.
All right, so now the date is the date and time for sentencing in the matter, and there's going to be both choice where Mr. Nash is going to go. I'm going to let the experts over there, you and Judge Holmes, deal with he's got a very serious problem, very serious. Mr. Johnson, are you ready? Are you ready for sentencing?
Yes, Your Honor.
All right, I'll let you, you said you've gone over the PSI. Is there any, thing you'd like to correct or, anything that is, that needs to be addressed?
Yes, just on page 2, I was told that the last paragraph, the third paragraph in the middle, it stated that the defendant reported that he began using cocaine at the age of 22 and that he uses it 2 times a week. I was just told that there was at least a 10-year period where he was not using any substances. I was told
that but the relevant part is he began using it at 22 and he says that he used it 2 times per week. Okay, so
Yes, sir.
it doesn't express whether that he stopped, and I don't believe he stopped anyway.
Understood, Your Honor.
You know, I didn't believe he didn't get caught. Anything else?
No other corrections, just in terms of elocution. I just want to state that he's 35 years old. I'm retained in the matter and always had contact with he and his mother, throughout this case. And he does live in Grosse Point. He's a graduate of Grosse Point South. There's no prior record now. Everything's been dismissed. I did pull his background yesterday to confirm that through the iChat. He does landscaping jobs. Now he is working. I talked to his mother yesterday and he was out doing the job at that time. Also, his mom, like I said, there's a medical marijuana card. I understand Your Honor's standpoint. I did receive that from his mother, as well as she sent over a policy excluding him from her insurance policy. So he's not driving any vehicle. They reiterated to me that he's no longer driving. He does have a mental disability as well. I would just ask that, and his mother stated, to sentence Mr. Ganesh to the drug court.
All right.
He does need help.
Yes, Your Honor.
On your behalf, sir, go ahead.
Yeah, I'll take the drug court.
I didn't think you didn't have a choice on that. I thought you were going to give me something else. You don't have to say anything on your behalf, but if you want to, now is the time.
No, I'm fine.
All right, it's going to be the sentence of the court to sentence him to the drug treatment court program. Ms. Warfield, what else do I need to do?
Your Honor, there's nothing more for you to do, Mr. Ganesh. Based off of everything that has been placed on the record, I believe that it's important that he gets in front of our team as soon as possible. So, Your Honor, if he could appear in person next Tuesday, the 17th at 9:30 a.m. in Judge Holmes' courtroom, we can get him started and getting him in process.
Next Tuesday is the 17th. That's June 17th at 8:30, you said?
9:30, Your Honor. In person.
In person, Judge Holmes. And what courtroom is that?
133.
Okay, you have it, Mr. Speed, sentence of the court to sentence you to drug treatment court, June 17th, 2025, 9:30, in person. You have to come down in person, Judge Holmes in court 133. I truly wish you the best of luck. I was hoping that, the testing and the lecture and all of that would help, but it's a much more serious problem than that. I hope that your mom realizes that as well. I think she does now. And I pray that you get this together, sir.
Thank you, Your Honor.
All right, I pray that you get this together. If there's nothing further, I wish you the best of luck, and thank you, Ms. Ganesh, for being here, and I do, the support for your son does not go unrecognized, okay?
I appreciate it. I
All
really
right,
do.
best of you both.
Thank you.
Thank
Have a
you.
good day.
Thank you, Your Honor. Have a good day.
Thank you, thank you. All right, Mr. Gregory, are you back? Is Mr. Gregory back? All right,
Good morning, Your Honor.
yes,
Hey, this is Officer Shobad on behalf of calling in for Grundy. Did he ever,
Grundy never appeared.
okay, so I'm all
So
set?
if you have any colleagues on Grundy as well, then you can let them know.
No, that's all right. Sir, you have a good day. Thank you.
Best of luck, happy Father's Day to you.
Thank you. You too. Bye.
All right. Who's next? We ready on Lopez?
We're ready on Gregory.
Yeah, Gregory never responded. Let's go back on the record with Gregory. Officer Bryant, good morning to you.
Good morning, Your Honor. I was here on Gibson.
Dwayne Gibson.
Yes, Your Honor.
All right, you came in after the cutoff time, Officer Bryant.
Yes, I was under the impression that this case was at 10:30. I looked at the wrong subpoena.
Okay, well, we're gonna dismiss, based on, I won't mark the file, I won't mark it, as not appeared, but I will dismiss because of the time.
That's fine, Your Honor.
All right, officer, let's call it. This is the city of Detroit versus Dwayne. Is Dwayne Gibson here? Let's find that out first. Yeah, he is.
Yeah.
Yes, I'm here.
He was here on time. This is the city of Detroit versus Dwayne Gibson, case number SP 1703918, counts 1 and counts 2. Appearance for the record, please.
Harry Boffman for the defendant. Would you, sir, please state your name for the record?
Dwayne Gibson.
The date and time for trial, Your Honor. The defendant's continuing not guilty plea. We ask you to consider a motion to dismiss without prejudice here for,
I'll just put the officer was late.
yeah, thank you.
All right. Officer Bryant, can you put your appearance on the record, please? Name and badge number and department. All right, I already spoke to him. Mr. Gibson, case dismissed. I'm waiving
Officer
warrant.
Bryant, 673.
And Detroit Police.
Yes, Your Honor.
All right, thank you for your service to Officer Bryant. I'm gonna dismiss. I won't mark was not no officer. All right, best of luck to you both. Happy Father's Day, Mr. Father.
Thank you. Happy
All right.
Father's Day to you as well.
Thank you. All right, let's go back on the record with Gregory, Devontae Gregory.
Excuse me, Your Honor. Is Gibson can go?
Yeah, Gibson can go.
Oh, okay. Thank you. Have a good day.
You as well, but I have an improper plate, improper equipment, and that accident was amended to improper equipment. The accident was amended to a red light ticket, huh?
That is correct, Your Honor.
And then the rest of the tickets were dismissed.
That is correct, Your Honor.
That's where your client in.
Yes.
All right. Let me draw your attention, Mr. Gibson, back to.
My name is Mr. Gregory.
Mr. Gregory, I'm sorry, let me draw your attention back to December the 6th, 2023, around 4:02 p.m. in the city of Detroit, in the area of Greenfield and Ellis. Did you have an occasion on that day to come in contact with the Detroit Police Department?
I believe so.
Well, they say you were operating a black 2016 Chrysler.
Yes.
You recall that?
Yes.
Did they ask you to produce valid insurance?
I believe so.
I don't think he's ready to take this.
Mr. Gregory, do we need to go back into a breakout room?
No, I don't know.
I mean, you have to know whether if you're trying to say you're trying to say you're guilty, you have to know that you actually did it.
Mr. Gregory, were you driving an uninsured vehicle that day?
Yes.
Find your client guilty of admitting kind of improper plate. Stipulate to the basis of the ticket as an act of factual basis for both responsible pleas as it relates to the other matters.
I would say so stipulated, Your Honor, but my client just dropped off of the Zoom.
Let's pass it. All right, who are we ready on?
Judge, we're ready on Lopez.
All right, let's go. Let's call the City of Detroit versus Ma Lopez, case number SP 166-411. Appearance for the record, please.
Este es el caso de las personas en contra Ma Teresa López, SP 1661-8411. Comparecencias, por favor.
Harry Boffman for the defendant. Would you, ma'am, state your name, please?
Harry Boffman representando la acusada. Señora, diga su nombre que conste en acta, por favor. Enciende su micrófono. You're on mute.
Teresa Martínez López.
Teresa Martinez Lopez.
Yeah.
Judge, this matter set for trial today, but there is a matter of discovery that is still left unresolved.
Hoy estamos aquí para juicio, pero todavía tenemos información que no está para resolver.
Would you please adjourn this matter for another date and time for trial so that we can get the discovery the prosecutor and I both agree is crucial in this case?
Entonces podemos tener un aplazamiento para juicio para conseguir la información que nosotros, yo y el fiscal estamos de acuerdo que es muy importante en este caso.
Okay.
Okay.
Was there a request made at any time?
Yes, Your Honor, the request was submitted, and I believe it was that on that date and time, Miss Walker was covering this courtroom. So that I never did receive the discovery, and that wasn't revealed until today.
Sí, su señoría, nosotros habíamos pedido, hubo una pedida para esta información, dijo el juez. La respuesta fue sí, yo había hecho esa pedida con la señorita Walker en esa fecha y en ese horario, pero nunca fue recibido y fue hecho en la misma fecha de ese antejuicio.
Okay.
Yes.
Una pregunta, ¿por qué se ha tardado mucho?
So I have a question. Why is it taking so long?
Well, your attorney is requesting discovery.
Tu abogado está pidiendo información.
Oh, okay.
Okay.
This case has gone back to January 24th.
Este caso ya hace desde el 24 de enero.
Sí, pues ya hace mucho.
Yes, it's been a long time.
That's correct, Your Honor, and there have been, to my knowledge, 3 separate and different prosecutors assigned to cover this particular case.
Sí, eso, usted tiene razón, su señoría, pero tuvimos 3 diferentes fiscales envueltos en este caso.
Sí, porque se me hace raro, ya llevo 4 cortes y no me han resolvado nada.
So, yeah, I think it's kind of strange. I had 4 court dates and we still haven't resolved anything.
That's not untrue.
Eso sí, no es mentira.
Well, I mean, what do you want? What do you want to do? You want I'm not inclined to grant another adjournment on this because it's just too long.
Let's see if we can resolve it today, Your Honor. I'm gonna renew my efforts to get a solution here today.
Entonces, sí, su señoría, ¿qué es que quieres hacer aquí hoy? Hace mucho tiempo yo no estoy en contra de dar otra fecha o aplazar este caso. El señor Boffman dijo, sí, vamos a ver, su señoría, si se puede resolver hoy, si podemos llegar a una solución.
Okay.
Okay.
Ms. Snyder and I can meet in room 3, please, with your permission, Your Honor.
Entonces, con su permiso, vamos a ir a la sala número 3.
Número 3.
That'll be room 4. But Ms. Snyder, what is your take on this? Why hasn't the discovery got to Mr. Boffman?
Entonces, para la señora Snyder van a ir a la sala número 4. ¿Por qué es que el señor Boffman no recibió la información?
Número 4.
Number 4.
No, not you, ma'am.
No, usted, señor, no está envuelto en esto, señora.
Ah, yo me quedo aquí mismo.
So I stay right here?
Yes.
Sí.
Okay, gracias.
Okay, thank you. Vamos a retirarnos de este caso por ahora.
Okay.
Mr. Whitey?
Good morning, Judge.
How you doing? We're waiting on you all morning.
I checked in at 8:30, Judge. I had to wash all evidentiary. I just got out and logged back in. We do have it resolved, though.
All right, have you spoken to your client?
Yes, Judge. Remember, this was adjourned from Tuesday. The interpreter had to leave, and we had a plea worked out where he was going to plead guilty to improper plates in exchange for the no insurance being dismissed, as well as the open alcohol being dismissed.
Entonces, so this.
We'll call it. This is the city of versus Lopez Jr. Case number SP 1685836, counts 1 and counts 2. Appearance for the record, please.
Good morning again, Your Honor. Dennis Whitey, P79560, on behalf of Mr. Lopez.
Este es el caso del el Estado en contra de Guillermo López, SP 16858361. Comparecencias, por favor. Dennis Whitey, representando al acusado, número de registro 79560.
Judge, we have this was adjourned from Tuesday because the interpreter had to leave, but we have a plea resolution that we wanted to accept.
Este caso fue aplazado porque la intérprete se tuvo que ir, pero tenemos una resolución en este caso.
And that deal that was offered was my client would plead guilty to improper plates because he had no insurance, and then the remaining count of open alcohol would be dismissed.
Entonces, La oferta era que mi cliente se va a declarar culpable para placas inadecuadas porque no tenía seguro y el cargo de alcohol abierto en un vehículo de motor se va a desestimar.
Is that what you want to do, Mr. Guillermo?
¿Eso es lo que usted quiere hacer, señor Guillermo?
Sí.
Yes.
Can you raise your right hand, please?
Levante la mano derecha.
Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
¿Usted jura y afirma de decir la verdad, toda la verdad y nada más de la verdad?
Lo juro.
Yes, I swear.
All right, you can put your hand down.
Baja la mano.
Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
¿Usted entiende que la pena máxima por esta ofensa es 93 días en cárcel y o una multa de $500?
Yo lo entiendo.
Yes, I understand.
You understand that you have an absolute right to a trial?
¿Usted entiende que tenés el derecho de ir a juicio?
Sí, lo entiendo.
Yes, I understand.
Mr. Baughman went over your other advisor rights in the breakout room, did he not?
El señor licenciado Baughman te explicó tus derechos en la sala privada.
Sí.
Repite, por favor. Repite.
Sí.
Yes.
You understood those rights?
¿Y usted entiende los derechos?
Sí.
Yes.
You have any questions about those rights?
¿Usted tiene cualquier pregunta de esos derechos?
No, no tengo ninguna pregunta ahorita.
No, I do not have any questions.
You know, by taking the deal, you're going to give those rights up?
¿Usted entiende que cuando acepta esta oferta renuncia a todos los derechos?
Sí entiendo.
Yes, I understand.
Has anybody offered you anything other than what's been stated in the record?
¿Alguien te ofreció algo aparte de lo que explicamos en la acta?
No.
No.
Let me draw your attention back to February 27, 2025 at around 5 p.m. in the city of Detroit, the area of Chopin and Wagner. Did you have an occasion on that day to come encounter with the Detroit Police Department?
Quiero que usted refiere a la fecha de 27 de febrero 25 a las 5 de la tarde cerca de la calle en la ciudad de Detroit. ¿Usted fue enfrentado de un oficial de policía?
Sí.
Yes.
Were you in a motor vehicle, sir?
¿Usted estaba dentro de un vehículo de motor?
Sí.
Yes.
Did the officer ask you to produce valid insurance for that vehicle?
¿Y el oficial de policía te pidió seguro válido para ese vehículo?
Sí.
Yes.
You couldn't do so, could you?
Y no lo pudiste hacer, ¿correcto?
Correcto.
Correct.
And why is that?
¿Y por qué es?
Porque no lo tenía en ese tiempo el seguro.
Because I didn't have insurance at the time.
Very well. I'm going to find your client guilty of the amended count of improper plate, which stipulates the probable cause. I'll dismiss the other matter now.
We so stipulate, Your Honor.
Entonces, yo voy a aceptar la declaración de ser culpable para placas inadecuadas y vamos a reducir, es el cargo reducido de no tener seguro y estipulamos a la causa probable y vamos a desestimar el otro cargo.
Okay.
$240, sir. When can you pay?
Su multa es $240, señor. ¿Cuándo lo puedes pagar?
Hijo de la fregada. ¿Cuánto es el tiempo que más me dan? Es que ahorita me acaban de operar y no puedo trabajar ahorita. Me hicieron una operación en la cabeza.
So, how much time can you give me? I just recently had surgery and I'm not able to work.
How much time do you need?
¿Cuánto tiempo necesitas?
Unos 15, 22 días.
¿Cuántos?
22 días.
Around 22 days.
I'll give them 30 days to pay it. Come back on July the 18th, pay it at any DivDat kiosk in the city of Detroit. I'm told you can upload the DivDat app to your phone, or you come on down to the courthouse and pay it in person. Those are the two best ways I can tell you to pay it. If there's nothing further, sir, have a very good day. Best of luck to you and hope fast recovery.
Usted tiene 30 días para pagar. Se puede pagar en persona en el tribunal del Distrito 36 o se puede...
Located in Warren County, state of Ohio. Defendant at that time was incarcerated as an inmate, that he did cause or attempt to cause physical harm to a corrections officer and employee of the Ohio Department of Rehabilitation and Corrections by striking him with a closed fist.
Anything on the facts, Mr. Moss?
No, Your Honor.
Did you hear those facts?
Yeah.
Do you admit they are true?
Yeah.
Do you understand the right you're giving up by entering a plea?
Yeah.
What's your plea?
To 9 months.
Yeah, what is your plea?
To assault and robbery.
Just the assault.
Just the assault.
Oh, okay. Just the assault.
What is your plea?
I plead guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think you've made a knowing, voluntary, and intelligent choice here today only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. Any reason not to go into the matter of the sentence today?
No, Your Honor.
Mr. View, anything else from the state?
Nothing additional, Your Honor.
Mr. Moss?
No, Your Honor.
Is there anything that you would like to tell me?
Me?
Yes.
I want to know my release date.
You want to do?
Would you be able to tell me my release date?
I don't, because I don't know when your release date is from the Department of Rehabilitation and Corrections. So your release date in this case is depending on when your case starts running, which is when you are released on your other case. And that I don't know the answer to.
May I say one more thing?
Sure.
I got medical conditions. I want to know if I can get early release. They not giving me nothing for it.
There's a number of different types of early release that are available to you. There is what we call judicial release. That's where you file a motion with me and I grant you judicial release on community control. You're eligible for that, but the odds of that happening are pretty small. You might also be eligible for transitional control or some sort of early release, 80%. Risk reduction, any of those types of things, that's decided by the prison, not by me. So if they decide that you're eligible and want to give that to you, I'm not going to say no to that. Okay? All right, I am going to sentence you to 9 months in prison. This will be consecutive to the time that you're already doing because the consecutive sentence is necessary to properly punish you, to protect the public. The overall sentence is not disproportionate to the conduct involved here or the danger posed by you. And I find that you're indigent for the purposes of fines and costs, so there will be no financial sanction. This does include a mandatory period of post-release control. That means the adult parole authority is going to supervise you from anywhere from 1 to 3 years after your release. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing any felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it would automatically can be consecutive to the time that you would receive for the new sentence. Good luck to you.
When I looked it up, it looked like your date was January 2027, right? So you had 9 months to that. Okay. I was thinking you would break it to us, okay? Okay.
All right.
It is 11. We're right on the tick. This is the time for a continued hearing. The matter of Clifton Harder versus Casey James Cap and others. Clifton Harder is here with his lawyer, Mr. Victor Bland. Casey Cap and others are here with their lawyer, Mr. Howard Bush. You're Amy Watson. All right, and their husband and wife. This has to do with a property on Burke Road in White Pigeon. We've been here on multiple dates starting in January. Had an opportunity to meet with Mr. Bush and Mr. Bland in chambers, and I believe we've reached a resolution. Give me just a moment. I'm trying not to sneeze. I'm not doing a very good job of it. At any rate, in chambers, excuse me. We learned that the matter has been resolved. The defendant is in a position to tender the purchase price of the property and proceed to a closing where the property would be sold. We did mention the escrow money. Escrow order was ordered in January. The defendant paid $403 for November and paid $1,612, $403, $403. I believe the total would be 6 months at $2,821 is how much escrow money the court holds. I may be incorrect. I have to check with the clerk. My order didn't enter until January 24th, so I guess it's, well, we'll find out. It looks like December, January, February, March, May, and June. I think I have $2,821 in escrow. Mr. Bush, do you want to set forth the premises?
Your Honor, please, my clients are now prepared to pay off the contract or the purchase of this property pursuant to the rent-to-own contract. We would ask the court to order that it be sale be closed. We would suggest Patrick Abstract in Centerville, and we would ask the court to, due to the discrepancies or possible abnormalities in title, we would ask the court to order title insurance to be provided by the plaintiff. We are ready to proceed at any time that this matter can be set up.
Do we know what the purchase price is?
The entire purchase price was $35,000. Is that correct?
It was, yeah.
And there were two purchase contracts. The initial contract and then the second one dated, was notarized on the 19th of June, 2023. And under that, there is an amortization schedule attached to that contract. And under that, the payoff in June of 25 is $13,180. Is that correct?
Yeah, makes about $48,000.
All right, do you agree with that, Mr. Bland?
Well, it depends on the amount in escrow, Judge. So
the escrow amount, I believe, and we'll confirm it. Elaine, if you can help me, I believe the escrow amount is 2008-21. There's no total on here, but help me with that, because I'm not sure if that initial.
Judge, I'm so sorry to interrupt you, but maybe if I can work backwards and then have a suggestion.
All right.
Because number one, what Mr. Bush outlined, we agreed to.
Yep. All right.
The only thing I'm going to suggest is that we let the title company determine what the payoff is based on what's in the escrow, based on payments and so forth. And that way we have.
I would agree to that.
We have a neutral arbitrator, as you are, Judge, but my guess is you don't want to see this again. And both sides can present payments, escrow amounts to them. But do I agree with Mr. Bush? There is an escrow agreement. We've all looked at it. I just don't really know where we're at. And let's have the title company figure it out.
I think we are looking at the same one.
Well, you've agreed to Patrick Abstract, and they're a reputable company right here in Centerville. It may take a little bit to get this finalized. So we can go a couple ways. We can file a conditional order of dismissal saying that it's going to be resolved, or we can simply set it out for about 30 days to give you time to complete the
I would
matter,
simply
and then we'll just dismiss it.
I would simply suggest we set it out. If we can get it closed, then it will be moot.
I agree with Mr. Bush. Let's set it up. Maybe 45 days might be more appropriate. Not that I'm trying to drag it out. Title companies sometimes don't move as fast as we'd like, and see if we can't get it closed in that time frame.
All right. I do have $2,821, and I can do an escrow order releasing the escrow funds to the plaintiff. Do you have any objection to that, Mr. Bush?
That is such.
All right. The escrow order won't continue into July. So, all right. So 45 days gets us into, I guess, early August. August.
That'll give us time to get it closed.
Let's see. I'm gone in late July. August 8th at 11. Does that work? I'm going to release escrow funds to the plaintiff.
That'll work, Judge.
All right, and the escrow order will expire. So you can make the payments to him, or you can determine what the payoff is at the time of the closing. But you guys have worked hard. There was a lot of confusion here. Different agreements, different dates. I'm pleased that you each had competent counsel to help us get here. So, Mr. Harder, let me ask you, did you hear everything that's been said here? Yes.
Yes.
And you're in agreement that the Caps can complete the purchase of this property. You'll sign the deed, transfer the property to them, and the matter will be closed. Is that correct?
Yes.
Mr. Cap and Ms. Watson, you agree you're going to complete the purchase of this, do a closing, and you'll own the property outright. And you're in agreement.
Can we also maybe set terms? You said since the escrow is closed, we can either pay him, or can we make that official? What we need to do, either pay him or set the payoff amount now?
Well, I don't know the payoff amount. June has been paid. What's your suggestion?
Well, maybe to make it easier, if you want to mail me the checks to pay the rent, is that what you're talking about until we close it?
Or do we just want to set it at payoff will be at this point And that will be the lump sum that he gets.
That's kind of what I want the title.
Well, that could include July and August rent.
Okay,
Right.
I thought she was wanting
I
payments
just don't
until.
want it to be ambiguous.
I
want to
understand.
be clear.
No,
where the money is going, and
I agree with that total. And that's why I suggested that we have the title company take your input and his input and figure it out.
and they will calculate it as of today.
Yeah. Well, as of whatever day they close. If it was today, June's rent has been paid. If it's in July, it would also include July's payment. If it's in August, it would also include August's payment.
I would hope we could get this thing closed within the next week or two. Not July.
We all want that, Chuck. We all want.
Well, I've given this target date of August 8th. Obviously, if the matter is resolved, you can simply submit a dismissal. And I'll take that day off. Don't worry, I got plenty of other stuff set there. All right, the parties agreed to the terms of this. They're going to complete the sale of this property. And I'll wait to see what happens. I'm expecting an order of dismissal. I will have the clerk prepare a release of escrow to the plaintiff. Should direct that to you, Mr. Bland?
That'd be fine.
All right, anything further?
No, sir.
All right, we're good to go. That record is completed.
I would inquire of my clients, is this settlement agreeable with the two of you?
Just a minute, I shut the record off. I thought I asked that, but Mr. Cap and Ms. Watson, is this agreeable to you? Yes.
It's agreeable.
All right, and Mr. Harder also agreed it's agreeable to him. All right, we'll complete that record.
Thank you.
All right, thank you all.
I will get a hold of Patrick. Do you want to get a hold of Patrick or do you want me to?
Why don't we both do it? I'm going to try to send him over right after we're done.
All right. Did you have a case down here today?
I was paying for this.
No, I'm sorry. You're good to go.
Thank you.
Oh, I forgot. I thought you just came here because you had a morning off.
No.
Anyway, it's nice to see you. I usually see you on Zoom, but I bet you're as glad as we are to bring closure to this.
Yes,
So,
I got one next week here too. So.
all right, thank you.
All right, up to you.
Well, why don't you let me send him over there and see if I can get it started? Yeah. Are you afraid of them all being there together? Or I can have him call later.
Yeah.
Why don't I do that?
Yeah.
I'll have him call later.
All right. All right. And I will come down.
Are you going to send your people over now? You're going to send your people over now?
I don't know if there's anybody over there to talk to at the moment.
Oh, I didn't realize.
Yeah.
Well,
I don't know.
all right. I'm going to tell him just to call later this afternoon.
Yeah.
I don't want to let it go. So,
Yeah.
okay.
Let me talk to him and I'll have you be in contact with him until we get it set up to who we're dealing with. Alrighty? Pardon? Yeah. Alright. But,
culpable para conducta desordenada y una sentencia retrasada de 1 año.
You want to take the deal, Ms. Lopez?
Señora López, ¿usted quiere disfrutar de esta oferta?
Sí, sí, soy culpable.
Yes, because I'm guilty.
Raise your right hand, please.
Levanta la mano derecha, por favor.
Do you swear or affirm? The other right.
La derecha.
Ah, perdón.
Sorry.
Do you swear or tell the truth, whole truth, and nothing but the truth?
¿Usted jura y afirma de decir la verdad, toda la verdad y nada más de la verdad?
Sí, sí, juro.
Yes, I swear. Baja la mano. Lower your hand.
Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
¿Usted entiende que la pena máxima por esta ofensa es 93 días en cárcel o una multa de $500?
Sí.
Yes.
Do you understand that you have an absolute right to a trial?
¿Y usted entiende que tenés el derecho de ir a juicio? Sí o no. Oh, yes.
No.
Mr. Bachman went over your other advice or rights in the breakout room, did he not?
Y el señor Boffman, el licenciado Boffman, ¿te explicó sus derechos en la sala privada?
Sí.
Yes.
You understood those rights?
¿Usted entendió todos esos derechos?
Sí.
Yes.
Do you have any questions about those rights?
¿Tienes algunas preguntas de sus derechos?
No, nada más quiero saber, ¿me va a llegar para pagar los 250 por correo?
So, no, I just want to know if I have to pay the $250 by mail.
You don't have any questions about the rights, right?
Usted no tiene preguntas de sus derechos, ¿correcto?
Okay.
Okay.
Do you have any questions about the rights?
Sus derechos, usted tiene preguntas de sus derechos.
Okay, no.
No.
Taking the deal, you're going to give up your rights.
Y si usted disfruta de la oferta, vas a renunciar los derechos. ¿Entiendes eso?
Okay.
Okay.
That's a yes or a no question.
Esa es una pregunta que tienes que contestar sí o no.
He understands that he could be found guilty based on this set of facts and circumstances and the possible testimony of the officers at that hearing. But he was not seen at that vehicle or anything, or seen doing anything, that his ID was in it, but it was not his car. So, and then Judge, on the second case, the traffic case, we would ask that you go along with, like I said, the negotiated plea of the case. He indicated he's 42 years old. He hasn't had any arrests just since that incident in 2023. And they indicated to me he wants to do what he's supposed to do so that he can hopefully one day file for to get his record clean. I said, and the way he can do this by getting a pardon. And you have to, go for a period of time and show yourself approved and be a good citizen. And certainly it's possible to do that. He was working. I don't know, you tell me you had any children. I'm sorry.
I have two children. 12 and 10.
12 and 10 years old. And I've talked with his significant other, the mother of those 12 and 10-year-olds, and he does support his children. And like I said, he's been to court whenever he was asked to be here. I think he is still on probation from that 2021 case, Judge. I understand that this is going to run concurrent with that. I think he had been compliant other than these cases. I don't know what they did when he got arrested on them, but this probation is to run concurrent with that. I think he has a year or two left on it, I'm not sure.
Okay, well, we're going to find out because Ms. Simpson's on the call, so she's going to get me up to date on that.
All right.
I'll turn to her in a minute.
All right.
Mr. Bateman, tell me what you do for a living.
Well, my uncle, he owns site. He come get me from time to time to help him out. I'm like a helper.
Okay, and your uncle does what?
He own his own business. He's the supervisor of the construction site.
Got it. So your uncle is in the construction business.
Yes.
And sometimes you help him with that.
Yes, but I had a job. I was doing road paving, but they laid me off because my feet is flat and I can't stand on my feet too long.
Okay. Have you ever applied for disability?
Yes, sir. That's what we're on right now.
Okay. How often do you do work with your uncle?
Whenever needed, he might just call me like I can leave here, call me and say, hey, did you come to work today?
Okay.
Stuff like that.
But is it typically like you do it once a week, once a month, 5 times a week? How often?
Lately, I've been doing so all this month. I've been doing all this month, but he just called me when needed because I'm his nephew.
Okay. And you said you were doing some work where they roll paper?
No, the name of the company is roll paving. When they lay down the asphalt on the street, they lay down. They lay down to my feet. Due to my feet is flat.
Okay. So what kind of work have you done where it doesn't hurt your feet?
Just with my uncle, he I'm going around looking the material, make sure everybody show up properly and sign the paperwork in and out, make sure everybody is there on time, stuff like that.
Okay, got it. You've got 2 kids. Do they live with you?
No, sir. They live with mom.
Okay. When you were here yesterday, you were with a young lady.
That's my wife.
That's your wife. So you're married. She's not the mother of the kids.
No, sir.
Okay. Does she have any kids?
No, sir.
All right. So just the 2 of you live together?
Yes, sir.
All right. And what part of Atlanta do you live in? Or do you live in Atlanta?
Decatur.
Decatur. All right. So you're a DeKalb resident.
Yes, sir.
Any reason why you would need to be on Donnelly Hollowell?
No, sir.
You don't have family that lives there?
Yes. My grandparents, they stay in 760 Alpha Road on Bolton Road. They've been living in the house 42 years. I'm 42 years old. They've been living in the house 42 years since I was a kid.
Your kids and their mom don't live off Donnelly Hollowell?
No, sir. No, sir.
Okay. All right. Good to know. Do you have any questions about anything?
No, sir.
All right. Well, Mr. Bateman, I find there's a factual basis for your plea in both cases. I appreciate Ms. Taylor explaining how it is that your wallet and your ID and your bank card ended up not just on the floorboard, but in the center console of the Altima that had the cocaine in it. And a jury would wrestle with it. They might say, I don't buy that. That's not your car. Or they might say, yeah, that's a tough one. We don't find that the state proved beyond a reasonable doubt that you were the only one who had access to the car. And if the state can't prove that, then maybe the jury doesn't find you guilty of the drugs. But it's risky to go to trial on that. And so you're saying I'd rather work it out. The other case, clearly that was you ran, they caught you, they tased you. Maybe you don't run next time if you run a red light and they pull you over. But you're pleading guilty to that. I find that your pleas are knowing and voluntary. Voluntary means no one's forcing you to enter these pleas, and knowing means you've understood all the things that Ms. Davis and I have been talking to you about. Do you agree with both those?
Yes, sir.
Then I'll accept your plea. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, if you have a technical violation, that means you miss a meeting or something minor, you and probation resolve it. You don't have to see a judge. If it's more serious, you get arrested for something, that comes back to me and we work through the consequences. Ms. Taylor, can someone in my office sign both indictments? I think one of them is technically an accusation, but both charging documents indicating Mr. Bateman's 2 pleas.
Yes, Judge.
Ms. Davis, can we sign for you?
Yes, Your Honor.
And Mr. Bateman, is it all right if someone signs on your behalf?
Yes, sir.
We'll do that. So I have to ask, yesterday you were dressed very nicely, red jacket, white shirt, and a frilly bow tie. Today we've got kind of maroonish velour, plum velour. Where do you get your clothes?
I go to Richie's and Saks.
Okay. And where do you get money for that kind of stuff?
My wife, she support me, and my uncle as well.
Your uncle, the construction guy?
Yes, sir.
Does your wife work outside the home?
No, she works from home. My wife, she actually works for the Boys and the Girl Club. She is what is that? She's like a wife. She is like a director for the Boys and Girls.
Okay. She's able to work out at home?
Yeah, she works remote from home.
Okay.
From a computer.
Got it. But she makes enough money that you get to dress like that?
Oh, yes, sir. Absolutely.
Okay. Well, I hope you treat her well. your two kids, boys or girls?
My 12 years old is a little girl, and my 10 years old is a little boy.
Okay, how often do you see them?
I see them like once a week.
Okay. All right. Well, Mr. Bateman, in 23 SC 191-437, I am sentencing you to 3 years probation. Special condition of probation is that you not be on Donnelly Hollowell Parkway. Don't be on it. Don't drive there. Don't go to a gas station there. Stay away from it. That street and you don't get along well. Okay?
Yes, sir.
So if you got to go visit your grandparents, figure out a way to get there where you don't go on Donnelly Hollowell.
Okay.
You'll submit to a drug and alcohol abuse evaluation. That's not me telling you that you abuse any drugs or you have an addiction, but it's going to have a doctor or a professional just talk to you about what you do and how things go. And if that person recommends any treatment, that might be going to some meetings or something, that treatment will be part of your probation. And finally, you'll need to complete 60 hours of community service. You'll need to have completed at least 30 of those in the first 6 months of your probation.
Okay.
All right?
Right.
We'll be reporting in DeKalb County. Ms. Simpson, who's on this call, is going to give you reporting instructions. But I think that's way out in Conyers somewhere where you first plug in.
Yeah.
You know where it is.
Probation officer. Nobody will know. No report.
And you may end up having the same probation officer. I don't know. You'll figure that out.
Okay.
You have a second case, and that is 24 SC 004271. Was the DUI, like, what makes this a felony? Was it all misdemeanors?
That is a good question.
Student judge, they lied. I heard.
Okay, just.
Oh, go ahead. Okay, let you tell.
Well, I'm curious why that case is here, not meaning in front of me, but it looks like to me 3
I said that
misdemeanors.
I said the same
marijuana.
thing.
You know, the GBI testing requirements for marijuana. So it was like over a threshold, but non-threshold, which we would test it.
And then the state decided not to prosecute that count?
Yeah.
Okay.
It wasn't tested.
Got it. So it got kicked over from state court to you all, and they're like, well, we'll keep it. Okay. Well, neither here nor there.
Right. And what he was trying to say was he fussed about that. I think it was the same officer involved.
Yeah.
It actually was the same officer from the 2022 case.
Another reason to stay off of Donnelly Hollowell.
That's the first thing I told him, Judge, when I looked at both the cases. Why would you go back over there?
Because that officer may be on that same beat, and he's going to see you. You've got a distinctive look, and he's going to say, you know what? You didn't signal, and you may not have signaled. He can pull you over because of that.
That's what he's saying. That basically and that's not that. He's been stopped by that officer several times with no charges. He feels like the officer's harassing him.
Well, I'm not going there. I don't know if
that's what I told him.
Officer probably doesn't appreciate some of the things you've done, but if you stay away from there, we don't need to worry about that.
That's right.
Here's what I'm doing with the case ending in 271. Count 1, the state has dismissed. Count 2, I'm sentencing you to 45 days in jail. Count 3, 45 days in jail. You've already done that, so it's a time served sentence. It's not going to say that on there. It's going to say 45 days in jail, but you're going to get credit for the time that you've already served. It doesn't make sense to put you on misdemeanor probation as well. That's actually a different agency. You'd be reporting in different ways. Super complicated. Last thing we need. You're going to be supervised. It's just going to be through felony probation. So 45 days to serve, count 2, 45 days to serve, count 3. That closes out the 24 SC case.
Okay, we understand that.
Ms. Simpson, how are you?
How you doing, Judge?
I'm great. How much time remains on Mr. Bateman's 21 case from DeKalb?
So that case is not in DeKalb, it's actually ours.
Oh, it's our case. It's being supervised in DeKalb.
Yes.
Yes.
Got it. How much time is left on that?
So he has 3 years, 5 months, and 22 days remaining. And he already had a revocation on that case.
That was question 2. So this plea is not going to create a revocation issue on the 21 SC case for Mr. Bateman?
No, Judge. He had his revocation with Judge Carnicel right after his arrest.
Got it. What did she do?
She revoked him. Give me a second because I already have it up. He was revoked 45 days and reinstated.
All right, there's that 45 days again. You're getting a lot of mileage out of those 45 days. Don't get arrested again while you're on probation. I might not give you just 45 days. You'll be on probation. It will be supervised out of DeKalb because that's your address. This sentence will end before your other sentence ends. You've got about 5 months more on that other case, but they're running together. It's one officer. You're not going to have to report in 2 different places or anything like that. Ms. Simpson, what are the reporting instructions for Mr. Bateman?
He needs to contact his supervising officer on June the 24th at 8 a.m.
Okay, meaning he should show up at the office, or at 8 a.m. he should call that number?
He can call his officer and they can advise if they need for him to come in the office. They probably do because they have to go over the conditions of this sentence.
Okay. All right, but now you've got me confused. On June 24th at 8 a.m., is Mr. Bateman supposed to be in Conyers at the probation office, or is he supposed to be picking up his phone to call officer so-and-so?
I would advise him to call before the 24th and find out if he needs to come in. And if they say, yes, you need to come in, then his reporting date would be the 24th.
Got it.
He needs to let them know, I've been given a reporting date for the 24th. If I.
Okay. Got it.
Okay, and he right now is on call-in, so he doesn't really have an officer. So I guess he would just call
He has an officer.
I know, but I'm just saying he because he calls in that there's no officer's name is what you're saying?
Yes, I want to know exactly who I call in, so I'm going to give. So
okay, let me give you that right now.
Okay.
Are you ready?
Yeah, I'm ready.
The officer is, I'm going to have to spell it because if I'm going to butcher this last name. It is N as in Nancy, G as in green, E as in elephant, N as in Nancy, E as in elephant. There's a hyphen, and then there's I as in igloo, G as in green, W as in west, E as in elephant.
Okay.
And the cell phone number is area code 470-423-1838.
Okay, we'll make sure that Mr. Bateman has this information in his phone before I leave here. Before he leaves here, we'll make sure he has this information. I have it, plus I will email it to Mr. Bateman to remind him.
Okay, thank you.
All right.
So, Mr. Bateman, you understand, you've got to make contact with that officer. That officer may say, don't worry about it, you don't need to come in. But you're telling that officer, I was given reporting instructions, June 24, 8 a.m. And that person is going to say, yep, I need to see you then on that day. Or that person may say, don't worry about it, here, we're good.
Date or whatever.
Yeah.
Right.
Okay.
But call them before the 24th.
Yes, ma'am.
If I'm you, I'm gonna call them, next week.
Yes, ma'am.
All right.
To put a real clear polish on it, if probation tells me you didn't show up on the 24th, they're going to give me a warrant to sign. I'm going to sign the warrant. So just make double extra sure that either you show up that morning at that place or your officer said, no, don't worry, you don't need to go. And then you're in a good space.
Okay.
All right? Ms. Taylor, anything else on behalf of Mr. Bateman?
Nothing else from us, Judge.
Ms. Davis, on behalf of the state?
No, Your Honor.
All right, I'm sorry you guys had to stick around that extra time, but better than going to trial. So appreciate all this.
All right, Judge. And I'll get a copy of the sentence as well and get that sent over to you, okay?
Okay.
I'll get that next week because the judge has to sign it, has to be filed in the clerk's office.
Yes.
Mr. Taylor?
Yes.
He's gonna he's gonna have to sign it when he report. That's why I say he's probably gonna have to go in the office just for that quick moment because there's a signature place on the disposition that they have to sign.
Okay. So he got to sign it
when he contacts his officer. That's why I say his officer is probably gonna have to have him come in. It'll be just for a quick moment, but there's a space that the defendants have to sign.
I'm gonna text it to you too. Make sure you got it.
Yes.
All right. Thank you.
Good luck.
Thank you, Judge. That's all I had to know.
Yes, ma'am.
June 24th.
Okay.
Judge, was those, the 3 years for both counts?
No.
There was only one count.
Oh, I'm looking at 2.
Well, let me look. I got the indictment here.
Just one count.
The indictment's just one. The calendar says 2 things, but the indictment is just cocaine.
Oh, okay. Thank you, Judge.
You're welcome. All right, so Ms. Nelson or Ms. Hansberry, anyone on this call, do I leave this up for the Singleton matter, or is DCS going to be dialing into the other Zoom, so I should end this? Thank you for sticking around. Appreciate it. Oh, no, you can be excused in just a sec. Mr. Armstrong's covering the motion for new trial. Are you going to make sure to do the bench warrants from the trial calendar?
Yes.
Good. Okay.
They get those done today.
Excellent.
Judge, I'm not sure. I'll have to check with Michelle.
Okay, I'll leave this up then. And it may, I know because we had that hang up with the civil matter. So I'll leave this up. I'm just going to mute it now. I just don't know what DCS is going to be dialing into. They assume they have the link to the session that kicked us off earlier. And Ms. Simpson, you're welcome to stay on, but it's motion for new trial hearing. So we won't be needing input from probation.
Okay. Thank you, Judge.
You bet.
Lucille Hall. No response. Would you like to take the call?
Yes, Your Honor.
Raise your right hand to be sworn.
There is a consent judgment, Your Honor, but the defendant has not appeared. We submitted it, she signed it, but she was informed she needed to be here to place her consent on the record. If the court is willing to take the consent judgment as presented.
I can't.
I understand.
That way, raise your right hand. Solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
Go ahead.
Thank you, Your Honor. This is a termination of tenancy case at a manufactured housing community. Defendant was provided with notice at the first hearing. Of the second hearing, the defendant has several outstanding violations for correcting the exterior of the home. The corrections have not been made since the filing, and we'd ask that the court issue a default judgment with a writ date of June 23rd, 2025.
Judgment to the plaintiff, that is by default.
Thank you, Your Honor.
Possession, no redemption amount, writ to issue as indicated in the judgment. So what I've done, so the record's clear, is I've taken the consent judgment, entered it as a default, and then signed it.
Thank you, Your Honor.
Court does call the case of Arbor Meadows versus Maria Herrera.
Good morning, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
Gotcha. All right, you've been sworn. I see that this is the same type of circumstance. You may proceed.
Thank you, Your Honor. We'd ask for a default judgment, similar circumstances. The previous case, it's a termination of tenancy for failure to remediate issues on the exterior of their mobile home. No money judgment entered. We'd ask for a writ date of June 23rd, 2025.
Judgment to the plaintiff by default for possession. No redemption amount, writ to issue the 23rd. Arbor Meadows versus Jaywin Root.
Your Honor?
Yes.
I just spoke with Ms. Robin Root, who's in the courtroom. Ms. Root, you want to come up?
That's the Jaden Robin Root.
Sorry, Mr. Jasmine Root is deceased.
Okay.
We have not entered an appearance in this case, but Ms. Root did reach out to me asking me to review this consent judgment that was signed. And I did review it for her, and I had some concerns about it that we wanted to bring forward. I was hoping to talk to counsel before the case was called to see if we.
I'll pass it.
Thank you, Your Honor.
Thank you.
Court calls case Esquapis versus Christine Griffin.
Good afternoon, Your Honor. Michael Burns, P 87855 on behalf of plaintiff, Mr. Dennis Quapis, who stands to my right.
And Pat Quapis. Christine Griffin, no response. You've been sworn. You may proceed.
Thank you, Your Honor. We'd request a default judgment, possession only, no money judgment to enter. There's a rent to retain of $3,420, costs in the total of $175.69 for a total of $3,595.69. And we'd ask for a writ date of June 23rd, 2025.
Judgment to the plaintiff that is by default for possession. Redemption amount is in the amount requested with the writ to.
Thank you, Your Honor.
Thank you. All right. And let me know when you're ready on that other one. Augusta Woods versus Anthony Wilson. That matters discussed on plaintiff's motion without prejudice. Court calls the case of Arbor Manor versus Patrick Brooks.
Thank you, Your Honor. Paul Hughes, P 31986, appearing on behalf of the plaintiff.
Hey, check. Brooks is also. Patrick Brooks?
Yes.
All right, there you are. All right. Where are we on this case?
Thank you, Your Honor. This case was adjourned. As you will recall, there were repairs that were made to a pipe behind the wall. The defendant has failed to pay rent, even though the repairs had been made. He was not giving access to the landlord to do the drywall repairs, and you told him to do that. He did provide access, and the drywall repairs have been made. The amount of rent due is $2,957. The last payment he made was in February, for $101. Court cost of $178 for a total of $3,132.
Repeat that number for me.
$3,135.
All right. Mr. Brooks?
Yes, sir.
The repairs have been made?
Yes, they just finished the drywall last night, but they have a couple more things to work on, which I'm not that concerned with. I was really concerned about the drywall because that was the main thing.
Okay. And so when is the rent going to be paid, sir?
I just need a little time. And a question I have, so even though I wasn't able to stay there for the past couple months, I can't be compensated in any kind of way for that. The drywall repairs were behind the toilet. They had no effect on the habitability of the unit. No, but they had to fix the drywall because the pipe was cracked, so I wasn't able to flush the toilet due to the fact I wasn't able to stay there because I couldn't use the bathroom. I understand they made the repairs promptly, but couldn't finish the drywall because access wasn't provided.
All right. Well, I had requested or had ordered a written answer to the complaint, did not get a written answer to the complaint. But, you know, if you're disputing the amount that's owed, then I'll sort it out. I'm going to set this matter for non-jury trial for July 1st, 2025, 9 a.m. That is in person for both parties. And that's a Tuesday. So we'll hear everything and then I'll render my decision.
Thank you, Your Honor.
Thank you. Court does call the case of Sycamore Meadows.
Judge, could I get a breakout room with Mr. Brooks in the meantime? And then what?
Mr. Brooks, do you want to meet in the breakout room with him?
Sure.
All right. Yeah, we'll put you into a breakout room.
Thanks, Judge.
Sycamore Meadows versus Tabria Story.
Good afternoon, Your Honor. Attorney Carrie Zanin, P67390 on behalf of plaintiff.
Good afternoon, Emily Brody, 88273.
All right.
Judge,
Where are we on this case?
This started with us being in front of you because of an order of eviction. So, Judge, I'm withdrawing the writ at this time.
All right. I will indicate that the writ is withdrawn.
Thank you.
Could you potentially indicate that the judgment amount has been satisfied?
Pardon?
I can't do that at this time. I don't have that documentation to show that, but I'm sure that it is. And give me a week and if I can get it done, I'll get it done.
Thank you. Sycamore Meadows versus Tarad LaFleur.
Again, Carrie Zanin on behalf of plaintiff, Your Honor.
Your Honor, I believe Ms. Lee was going to appear on this.
Is that who you were talking to? Ms. Lee?
I haven't spoken to anyone today. I was supposed to meet someone today, but I haven't spoken to anyone today.
I do believe that.
I'll pass it. Have a seat. Sycamore Meadows versus Erica Jimerson.
And Carrie Zanin on behalf of plaintiff, Your Honor.
What?
I believe Ms. Lee is also.
Then I'll deal with it. I passed it. I guess Ms. Lee is dealing with it. So as soon as they get back in here and she graces us again with her presence, I'll call her. All right.
Okay, Judge. I don't believe I have an appearance for either, but on either file yet. So.
Yeah, I know. I never do, which is really irritating, but okay. I understand your frustration.
Thank you, Judge.
Avalon Housing versus Yolanda Shepard.
Good afternoon, Your Honor. Jillian Engen for plaintiff.
Good afternoon, Your Honor. Andrew Campbell, on behalf of the defendant. We have talked, Judge. I believe opposing counsel wants additional time, and I have no objection to that to respond to the motion. Oh, sorry. My client is here as well, Judge. We have no objection. We're still trying to work out a settlement.
I thought we were resolved. Or going to be.
We were trying to resolve. I believe there's.
What's the hang up?
Your Honor, so Ms. Shepard is first in line for new housing. I think that once she has new housing in surrender's possession, I think that this case will be moot, and so we'll be able to hopefully dismiss it at that point. And Your Honor, I also, I don't know if has Your Honor signed the order that was submitted under stipulation? I don't know that we have a copy.
Right, that's correct, Judge. And
the order prohibiting occupancy. And on June 4th. I have just signed it.
Thank you, Your Honor.
Yeah, and that's, Judge, just for the record, that's not a final order because we still have.
I understand that.
Okay, I just want to make it clear, Your Honor, I'm sorry. And did you want a deadline?
Your Honor, could you adjourn this for 2 weeks? We will respond to the motion for summary disposition by the 25th. I think that's the 21 days since it was served. And then I think Mr. Campbell also asked for a reply to the answer. And so we will have that submitted as well by the 25th.
I'll set this for the motion, for hearing on the motion, and yeah, I'll just set it for that at this point. July 1st, 2025, 9 a.m.
Thank you, Your Honor.
Court calls case people of Evergreen Apartments versus Kayla Smith.
Plaintiff.
Hello.
Hello.
What's your name?
Kayla Smith.
All right. Where are we on this?
Your Honor, Ms. Smith has brought her balance down to $516.41 inclusive of costs.
How much?
$516.41.
No, I know. No.
And Your Honor, DHHS is paying the remainder, so
they're going to be okay.
Time for them to get that paid.
I think a week should do it because they were supposed to submit payment on the.
Okay, my next available date is the 27th. So what I'll do is I'll adjourn it to June 27th, 2025 at 2 p.m. That's an in-person hearing, but if everything's paid, you're good.
So I don't have to come if everything's paid?
Don't look at it like that's a favor. You don't want to come see me? Is that?
I mean,
no,
I like to see you.
No, that's
But
okay. That's
childcare is hard
no.
to find. Okay, 27.
I'll answer your question now. If everything's paid, you don't have to show.
Okay, good.
Okay, just double check it. You may want to call.
Verify with Sydney.
Okay.
Sydney
Okay.
will keep you updated.
Okay.
All right, you have a great weekend.
Thanks, you too.
Omar Apartments versus Caden Duford.
Jillian Ingan, plaintiff.
You got him in all.
Yeah, he did check it in person.
Caden Duford, can you check that? Huh? Yeah.
And Your Honor, just so you know, we are requesting leave to amend. There was a 1 month notice to quit sent. And so.
Got it.
Requesting leave to amend.
No, you don't want to. Okay. $7. No answer. You're sure he was here? Yeah. And you're sure they were here?
Someone answered yes when I called Caden Duford.
All right, let me pass it.
Thank you, Your Honor.
Glencoe Hills versus Tillman McCommons.
Jillian Ingan for plaintiff. Also checked in.
Hello. Hello, sir. Yeah. Your name?
Tillman McCommons.
All right, this is your motion to set aside the judgment?
Yes.
What's the basis for the motion to set aside, sir?
I was here last time. Finch, he gave me the wrong time for my appointment, and he left and
got it.
And went into default.
Okay. Did you? This was the one in.
Yeah.
Okay. So apparently there was a time that issue. He was here, but his time was wrong. So I'm going to grant his motion to set aside.
I believe, Your Honor, that we have filed a writ, and so we can withdraw that.
Yes, and the writ's withdrawn. All right, and balance is what at this point?
I have a balance, including court costs, Your Honor, let me just verify this, of $4,373.71.
All right. And sir, how are you intending on getting that paid?
Well, I can pay today. I got like 1,300.
All right. Have you tried to work something out with the landlord regarding?
I've been corresponding back and forth with her about that, and I talked to her last time. She said my judgment was like 1660.
Well, your judgment was 2888.15. I set that judgment aside, but that was from May.
Okay, and then I came in to pay the motion. I paid like 1,200 for the motion.
Did you put 1,200 in?
Yes.
You certainly did, sir. He put $1,254 in. And you have how much today?
I like 1,200.
Gonna bring it down below 3,000.
Right. And are you working with Hawk at all?
I got denied.
Okay. All right, let's do this. I'm going to release the escrow to the plaintiff. Okay, so what you put in, I'm going to order it released to your landlord.
Okay.
Okay. You have 1,200. I want you to pay the 1,200 today to the landlord also. Okay.
Okay.
And then what I'll do is I'll adjourn this out to June 27, 2025 at 2 p.m. to figure out how we're going to deal with the rest of the balance.
Okay.
Okay? All right. Thank you, sir. Court does call the case of Glencoe Hills versus Devonta Jackson. Okay. And LaChina Williams. They did ask for what?
To appear Zoom, but I don't have either individual.
Devonta Jackson, LaChina Williams. Neither are here. Would you like to take a default?
No, I'm here.
Oh, you're here. Okay, your iPad. She usually has her name on.
Yeah, and then you should.
All right, go ahead. Okay, folks, I need to move this docket.
All right, thank you. Sorry, Your Honor. Jillian Egan.
All right, this is LaChina Williams. She's here and didn't even credit me for getting her name right. No, I'm not going to say anything. Don't worry about it. Everybody's been hurting my feelings today. All right. How much do we have owing on that? It might be under Devonta Jackson.
I see it. Okay. Thank you. That's fine. I have a balance including court costs of $3,031.61. I have an update from my client that Hawk is, that they are currently on a waiting list for funding. They're hoping they can make their request soon and they will reach out when they have more funding and can submit the request.
Okay. But we don't have an idea as to when that's going to happen.
Right.
So are they thinking that it's even going to be before the end of the month or?
I don't know. Sorry.
All right. Well,
Your Honor,
yes.
if maybe if the defendants could put some funds into escrow with the court, then it wouldn't necessarily, if they, I mean, they're over $3,000 right now.
Right.
You can get that paid down and then any extra put.
Ms. Williams?
Yes, I plan to pay it down as much as I can, but I know I won't be able to pay the whole balance. That's why I was just going to wait on Hawk.
Okay.
Because I know July charges are going to come in effect as well soon.
Yes. So let me ask you this. If I ordered you to pay funds into court escrow, how much do you think you can pay?
I could pay $400.
Okay. So let's do this. Give it a chance to try to figure it out. Pay $400 to court escrow. All right. And that means you come down with cash to the court and put it in there. Okay.
Okay.
And so get that in, and then I'll adjourn this out to my next date, the 27th, 2025 at 2 p.m. And then we'll see exactly where we are. I may have to issue a judgment at that time, but at least we'll know for sure where we are. Okay.
Okay. Thank you.
Thank you. Court calls the case in Hamilton Crossing 1 versus Victoria Bolton. Hello.
Hello,
What's your name?
Victoria Bolton.
Thank you. All right. And where are we on her case?
I have a balance including court costs of $2,237.
All right.
And I made a payment last week as well, and I plan on making one today.
Last week of $300?
Yeah.
Okay, I see that on the ledger.
Okay, was that taken into account?
Yes, Your Honor.
Okay. You said you plan on making another payment?
Yeah, but I feel comfortable putting in escrow right now.
Pardon?
I feel more comfortable putting it in escrow through the court versus giving it to them.
Why?
Because I just have a lot of pending work orders that's from like January. They don't really like repair anything. They told us if it's not an emergency.
So you're going to put it into escrow?
Well, today I'm gonna do 300.
All right, you need to put $300 into escrow. You need to give a written list to the landlord of those repairs.
Mm-hmm.
Okay, that you're saying that are going to be needed.
Okay.
And you're to do that by, you're to do that by this Wednesday, the 18th.
Okay.
With a copy of that list to the court.
Okay.
And then I'll adjourn this matter to June 27, 2025, 2 p.m.
Okay, thank you.
Thank you. Hamilton Crossing 2 versus Ashley Jordan.
Jillian Ingham for plaintiff.
Ashley Jordan.
I think she did.
She went where?
She's talking with legal services.
Okay. Hello. Your name?
Ashley Jordan.
It's a termination.
Yes, Your Honor.
I have not had a chance to speak with Ms. Engen yet, but I just spoke with Ms. Jordan, and we had spoken before about her situation. And I'm willing to enter an appearance in this case, but I'm hoping that we can work it out with Hamilton Crossing.
I'll indicate here that legal services is going to enter an appearance. And what I will do is I'll adjourn this out June 27, 2025, 2 p.m.
Thank you, Don.
Thank you, Don.
Thank you. Hamilton Crossing versus Jessica Jackson. Hamilton Crossing.
Jillian Ingham for plaintiff.
Hello.
Hi,
Your name?
Jessica Jackson.
All right. What's plaintiff's claim in this case?
I have a balance including court costs of $1,118.
All right. So she got that $1,000 in. How are you going to get the rest paid?
I have a money order in my car for 500.
You have a money order in your car?
Yes.
Why'd you leave it in your car? No, never mind. Nah, okay. I don't care.
I had just,
Yeah, 500 in the car.
yes, but I had just got paid and I didn't want to be late for court. So,
You didn't want to be late for court?
no.
Oh.
So,
Valid. Valid.
That's nice. That's nice of you. Okay. So you have 500, then how long is it going to take to get the rest of that? You got about another,
I have to pay Friday. Next Friday.
the 20th next Friday or the 27th?
What's today?
Today's the 13th. So 2 Fridays from now would be the 27th. And
18th.
next Friday's the 20th.
The 20th.
You'll have it paid by the 20th?
Yes.
All right, so what I'm gonna put in here, you pay $500 to the landlord today. All right, and then I'm gonna mark that you're gonna pay the balance by the 20th. I'll adjourn this matter to June 26, 2025 at 2 p.m. If you've got everything paid, I don't need to see it, not that I wouldn't want to. Okay, before you hurt my feelings and say you don't want to come see me, all right?
Okay, thank you.
I'm sorry, it's the 27th, Ed.
27th?
Yeah, next Friday.
Thank you.
All right, or 2 weeks. Or court calls the case of Hamilton Crossing 2 versus Jeffrey Williams.
Jillian Engen for plaintiff.
And hello.
I'm Shirley Williams.
All right. And what's the claim now?
I have a balance including court costs of $811.
All right. How
I'll
are we
be
gonna
paid
get
on-
that paid?
On the 20th, I'll be paid.
You can pay it all on the 20th? All right, then I'm gonna put, you're gonna pay 811 on the 20th. I'll adjourn this out to June 27th, 2026, or 25. I don't know why I wanted to, I don't know why. At 2 p.m., okay?
Thank you.
And if you're paid, I don't need to see it.
Okay.
All right.
Thank you.
Here, let me break in here real quick and try to get Miss Zana now. I think they said they're ready. Are you ready on the Sycamore Meadows cases?
Yes, sir.
Sycamore Meadows versus Erica Jimerson.
Again, Carrie Zanon on behalf of plaintiff, Your Honor.
Emily Brewer for the Emily Brewer, the AHU.
All right. All right.
Judge, we
What are
are
we doing
working
on
to
this
resolve
case?
this. We are trying to work to resolve this. Can we adjourn this to the June 27th date?
Any objection? Case is adjourned June 27, 2025. What time is, are they? At 3 p.m.
Thank you, Judge.
Thank you. Sycamore Meadows versus Tyrod LaFleur.
Again, Carrie Zanon on behalf of plaintiff.
Again, Emily Brewer for defense.
All right. What do we want to do? Hello, Miss.
Judge, the same thing as the previous. Can we adjourn this to June 27th?
All right. All right, Mr. LaFleur, I'm going to adjourn your case out to June 27, 2025, 3 p.m. Okay. All right. Thank you, sir.
Thank you, Your Honor. Have a wonderful weekend. Happy Father's Day.
You do the same. Were you ready? Court recalls case of Arbor Meadows versus Jaden Root. Jaden Winnie.
Good afternoon again, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
Good afternoon, Your Honor. Officially, I will be entering my
Robin Root.
behalf of Ms. Root. And I believe counsel and I have agreed that we are going to submit a new conditional order of dismissal in this case with some additional protections for the defendant in that she will be required to maintain the home site in accordance with rules and regulations of the park for 12 months until June 10th, 2026. But if plaintiff alleges that there has been a violation of those rules and regulations, they will notify us as counsel and Ms. Root and give us an opportunity to respond and object and have a hearing.
Is that basically it, count?
That's correct, Your Honor.
Are you guys going to put that together? And
I'm going to draft a conditional order of dismissal this afternoon, Your Honor.
all right. Then I'll adjourn this out to June 27, 2025 at 3 p.m. If you guys have that, then I can enter it if they're both sides are represented by counsel.
Thank you.
Your Honor.
Thank you. Court calls case of Huron Vista Apartments versus Sabria Williams.
Jillian Engen for plaintiff.
Andrew Campbell, on behalf of the defendant, Your Honor. I believe we needed a ledger, and Ms. Ingen is going to give me one today, Your Honor. so that we can have time, so we can get an updated amount and get that paid, Judge. So I believe opposing counsels will consent to an adjournment of 2 weeks.
Yes, Your Honor, we're happy to adjourn. And for the record, the total balance, including court costs, is $478.
$478.
Yes, sir.
June 27, 2025.
Thank you, Judge.
2 p.m.
Thank you.
Thank you. Court does call the case of Huron Vista versus Alicia Moore.
Jillian Ingen for plaintiff.
Alicia Moore. Not checked in. Would you like to take it to vote?
Yes, please, Your Honor.
All right, I don't think they've sworn you in. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
Thank you, Your Honor. This is a case for non-payment of rent. I have rent to retain possession of $4,485, court costs of $176, for a total of $4,661. Plaintiff is requesting a default judgment for possession only with a writ to issue after July 5th.
July 5th.
2025. Your Honor, we're going to set this aside if Ms. Moore pays $1,661 on or before July 5th, then we will set this judgment aside.
Gotcha. Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with the writ to issue as indicated July 5th.
Sorry.
Court does call the case of Huron Vista versus Jacqueline Taylor.
Jillian Ingen for plaintiff.
Hello.
Jacqueline Taylor.
Good afternoon.
Okay, she's here. Your name, please?
Jacqueline Taylor.
Thank you. All right, what are we on?
Your Honor, I have a balance including court costs of $2,413.03. I believe that we are looking to enter, I believe that Ms. Taylor is participating in the forgiveness plan.
Okay.
Be drafting a conditional order of dismissal.
All right, is that correct, ma'am?
Yes.
All right, do you want me to adjourn this out?
Please, Your Honor, to the 27th.
Okay, ma'am, I'll adjourn your case to June 27th, 2025 at 2 p.m. All right?
Yes, sir.
All right, and hopefully we'll have everything all resolved by then. All right, take care.
Okay. Thank you. You as well.
Court does call the case of Huron Vista Apartments versus Danielle Davis.
Jillian Ingen for plaintiff.
Danielle Davis has not checked in. You may proceed.
Okay. Your Honor, I believe that this is a motion hearing.
This is a motion to set aside default. Danielle Davis, defendant having failed to appear. Motion to set aside is denied.
Your Honor, may I ask, is there escrow in this matter?
Yes, we have $500 in escrow.
Okay,
So escrow to plaintiff.
thank you, Your Honor.
Court calls the case of New Park Ridge Apartments versus Alana Armstead.
Jillian Ingen for plaintiff.
Hello.
Hello, Ms. Armstead. How are you?
I'm good, answer.
Good. All right, where are we on this case?
I have a balance including costs of $1,575. Ms. Armstead and I did discuss briefly this matter. She's going to make another payment of $300. Is that correct?
Yeah.
And then she's getting assistance.
Through the Breeze program, through Michigan Works.
Through what?
The Breeze program, through Michigan Works.
Okay. So she's gonna, when are you gonna pay the $300?
Today.
Today. All right. So you're gonna pay the $300 and then you're gonna get assistance that you think will take care of the whole thing?
Yes.
All right. So let me adjourn this out to June 27th, 2025 at 2 p.m. for you to, see if all that comes through.
All right, thank you.
All right, thank you. Court does call the case of New Park Ridge Apartments versus Karina Jones. Ms. Jones?
Yes, I'm here. I'm trying to do my video and stuff.
What'd you say?
I was trying to do my video.
No, you got it. Okay. All right, where are we on this case?
I have a balance including court costs of $1,901.
All right. And ma'am, how are you intending on getting that paid?
Right now I'm going through Hawk. I'm trying to figure, I've turned in all my documentation, so I'm basically waiting on the response.
You're waiting on a response from Hawk?
Yes.
Okay. Do you have any notes regarding that?
I do not, I'm sorry.
All right. Okay, ma'am, what I'll do, we'll give them time to see if there's going to be a response. I'll adjourn this to June 27th, 2025 at 2 p.m. Okay?
Right. Thank you so much.
Thank you. Have a good weekend.
You too. Here.
Let's call the case of New Park Ridge Apartments versus Precious Terman.
Lillian Egan for plaintiff.
Yep. Somehow I knew Precious was in the house. Come on. Hello, what's your name?
Precious Terman.
All right. And what's the claim in this case?
I have a balance including court costs of $4,954.
All right. How are you intending on getting that paid?
Honestly, I feel like the whole process is a fluke because I'm low income and my rent is really only like $180 or something like that. And they're charging me market rent because they said that my recertification wasn't complete in a timely manner, which it was supposed to be done in January. I have been here 8 years and never have I had that completed in January due to the lack of them telling me what paperwork to turn in. I'll turn in a paper. They'll come back and tell me I need another paper.
Have you spoken to legal services at all?
I have not.
I'll give you an opportunity to speak to legal services since you're indicating that it's a,
Yeah, 500 of this balance is coming from them trying to charge me for my security deposit, which again, I've been there 8 years.
Okay. I don't know that. I don't have a ledger in front of me.
I have one.
But what, okay, that's not going to help me right now. So what I'm going to do is I want you to at least reach out to legal services or actually present in the courtroom and talk to them.
Okay.
I will adjourn this out to June 27th, 2025 at 2 p.m. All right. Thank you. Court does call the case of Peninsula Place Apartments versus Jacqueline Gardner. Gardner?
Yes, hi.
Hi, how you doing? I'll need a camera if you can.
Okay, 1 second.
All right, and what's the plaintiff's claim in this case?
I have a balance including court costs of $2,406.06.
Okay, $2,406.06?
Yes.
All right. And Ms. Gardner, how are you intending on getting that paid? You're muted.
Yes, sorry, I had the baby in my hand.
Okay.
I'm still working with family to get it paid off. I go back to work in like 2 weeks and a couple of days, and then I should be able to make some payments myself. But I'm not sure, like, if it can keep getting adjourned or not.
Okay.
From my maternity leave.
But you're talking. I remember because the maternity leave. I remember, and you don't qualify because you're on maternity leave, and yeah, that crazy system we have. So,
yeah.
All right.
Sorry, I'm holding the baby.
So you had your baby?
Yes, I'm holding him.
How old is he now?
He's 2 weeks, going on
That's
3.
what I thought.
Yeah.
Well, first of all, congratulations to you.
Thank you.
All right. What's the name?
Jace Jameer.
Jameer? All
Jace
right.
Jameer. Yep.
J. Jameer. Okay. All right. Well, I know she's been working with family, and this was a no-win situation for her. So the court's going to adjourn this out 2 weeks to the 27th, 2025 at 2 p.m. We'll do that in honor of the baby. Okay?
Thank you so much. Thank you.
You're welcome. All right. We'll see you in a couple of weeks. You take care.
Okay. Thank you too.
He met you. He didn't give you much.
Provident Asset Management versus Sandra Moore. Here. In
Here. I'm here.
Okay. Where are you? Okay, I'll need a camera. Where are we
Okay.
on this case?
I have a balance including court costs of $2,515.05. I think that there was, we were trying to get an update from Hawk at the last hearing.
Right. Ms. Moore, have you heard anything from Hawk?
No, the only thing, I did. She said that she was reviewing my documents, but I sent them in 4 weeks ago.
Okay. Ms. Moore, here's what I'm going to do. I'm going to adjourn this out to the 27th, 2025 at 2 p.m. And let's see if what we could do is try to get an answer, good or bad. All right?
Okay. All right.
All right. Thank you.
All right. Thank you.
Court calls case People versus, or Faith Shepherd versus Lakrita Thompson.
Yes, can you hear me?
Yes, who are you?
I am Lakrita Thompson. I am the defendant. I guess you had them the defendant. Yes.
The defendant. Okay,
Yeah.
I'll need a camera.
All right, here I come right now. Oh gosh. Oh, wait a minute. How do I do this? How do I turn my
This is a termination?
Yes, it's not, it's gosh, why did I get my camera on? Oh, this is weird.
Yeah.
This is a termination initiated by a notice to quit for a 1 month notice to quit for a month-to-month tenancy.
All right.
Okay.
All right, Ms. Thompson?
Okay, hold on right now. I'm doing it right now. Yeah, can you see me now?
I now can see you. All right.
Okay.
This is a termination of tenancy. You had a month-to-month tenancy?
No, I have a 2-year lease, Your Honor. I've been living here for 7 years. I also have managed properties for the owners. Right now, my lease is up in 4 months. I just got a notice. I don't have a problem if she wants to retrieve her property. I mean, her property here, her residence is fine with me. But I only have 4 months left with my lease.
So hold on.
I need time.
Hold on. So you're saying it's a month-to-month?
No, I have a 2-year lease.
Ma'am, stop. Plaintiff is saying that it's a month-to-month. You're claiming that there's a lease. I don't have a copy of the lease. Do you have a copy of the lease?
No, actually, I don't. I gave it to the owner's daughter 2 years ago. And I haven't had it, sweetheart. No, I haven't. So, Your Honor, I don't have it. She has it. So it's never been a month-to-month. As long as I've been living here, never been a month-to-month. I've been living here for 7 years.
How long have you been living there?
7 years. And I also manage properties for the owners. There are other properties that they have.
All
so
right.
I was maintaining.
So here's what I'm going to do, because that's certainly a dispute as to it. So I'm going to set this for a non-jury trial, July 1, 2025 at 9 a.m. That's an in-person hearing, so you'll need to be here, ma'am. And they'll have to have somebody and show me either that there's no lease, or you'll have to show me that there's a lease. But then I'll make a decision on it, okay?
Okay, also, I'm also leaking out legal help, legal representation.
All right, that's fine. You can have legal representation come with you on that date, but I'm going to set it for trial on that date.
Thank you so very much. And you have a beautiful day. Thank you so much.
You do the same. Sparrowwood Apartments versus Regina Agnew.
Step out, Your Honor. She's here to step out.
Strong Future Homes versus Lolitha O'Day. Lolitha O'Day. Where is she?
She's outside. She's talking to legal services.
Better pass it. Court calls the case Strong Future Homes versus Cedric Moore. I got that right. Hello, your name?
My name is Cedric Moore.
Cedric Moore. Okay, I messed it up. Why are you laughing? Why are you laughing? Look at how it's spelled. I mean, it actually is spelled exactly as she said it. However, not where I would put I wouldn't break the name apart that way. Anyway, all right. I apologize.
It's okay.
All right, what's the plaintiff's claim on this case?
I have a balance including court costs of $560.
All right. And ma'am, how are you intending on getting that paid?
If I can, I would like to pay it by the end of the month.
Okay. When you say by the end of the month, what day can you?
I can pay it by the 30th, but I get paid on the 25th, but I just want to give myself some grace.
All right. Well, okay. If you get paid on the 25th, can you get it paid by what time were we set to?
2 p.m.
By say noon on the 27th?
Yes.
Can you get it paid by then?
Yes.
Because if you get it paid and they know, then the case can get dismissed.
Okay.
Okay.
That's fine.
So I'll adjourn it out to the 27th, 2025 at 2 p.m. You'll get that paid before noon.
Yes. And I have to come here. Can I pay online? I have to.
You can't.
How you normally would pay.
You pay, yeah.
Okay.
And if you can pay it on the 26th, that would be even better.
Okay.
Yeah.
If possible, because then they'll get ledger.
Okay.
And hopefully it'll be dismissed and you don't have to show back up.
Okay.
And then I don't have to try to butcher your name. All right.
Thank you.
Thank you. Thank you. Court calls case Strong Future Homes versus Jamie Kaiser.
Jillian Ingen for plaintiff.
Good afternoon, Your Honor. Andrew Campbell on behalf of the defendant. Judge, today I filed an answer affirmative defenses in an appearance, and for the record, I'm personally handing a copy to opposing counsel.
Where was that filed?
That was filed
that today?
Yes, Your Honor.
That's right.
And Judge, I do request a week to file a counter complaint. There is a cause of action under the Regulation of Collection Practices Act because this debt's been paid already, and it's pursuant to a previous case that you signed a condition.
If it's been paid, then why can't you just work that out?
Well, we can, but
file what you want to file. June 27, 2025. 2 p.m.
Okay, I'll file that counter complaint within a week, Judge.
I'll do what you're going to do.
Thank you.
Court calls the case of Strong Future Homes versus Alana Lindsay.
Jillian Ingen for plaintiff.
What's wrong, ma'am? Were you trying to get us our attention?
Yes, they call her case. Regina Agnew. I had to go to the restroom. You know, you make me so nervous. I had to get back.
Whoa. I made you nervous?
In a good
in a good way. Oh.
Let my neighbor that I'm sitting by know that if they call my name, I have to go to the restroom.
You know what? I knew it was you, so I waited for you to walk out, and then I called. No, I'm kidding. I'll call you back up momentarily, ma'am. Strong Future Homes versus Lindsay. Your name?
Alana Lindsay.
All right. Where are we on this case?
Your Honor, I have a balance including court costs of $486.
All right. you were gonna get that paid. That's what you
Yeah.
told the court last time?
I just haven't got paid yet. The last court date was like last Friday, and I get paid every 2 weeks, so it just hasn't happened yet.
Okay, so when do you get paid?
Wednesday.
This upcoming Wednesday?
Yes.
Okay, all right. So it said you're gonna pay it in full by next week, but maybe that, okay. But I wasn't the judge on the case. So here's what I'm gonna do. I'll adjourn it to June 27th, my next date, 2025 at 2 p.m. Okay?
Okay.
Get that paid, all right? And then you don't have to come back and see me, so I don't make you nervous.
Thank you.
You're welcome. I said it. Yeah, I said that for you. Strong Future Homes versus Charles Ellison.
Jillian Inges for plaintiff. He might be in suit.
Mayor, can you hear me?
Hello, what's your name, sir?
Charles Ellison.
All right, he's here. All right, just turn on. There you are. Okay. All right, where are we on this case?
Your Honor, we're requesting to adjourn to the next hearing date. My client's doing some recalculations on the ledger.
All right. You have any objection to that, sir?
No, sir.
Okay, I didn't think you would. June 27, 2025, 2 p.m. All right?
Yeah, thank you.
Thank you. Strong Future Homes versus Chanel McFarland.
Jillian Inges for plaintiff.
Hello.
Hello, we meet again.
What's your name?
Chanel McFarland.
Thank you. All right, where are we on this?
Your Honor, I have a balance including court costs of $6,817. I understand that Ms. McFarland is contesting it. I think that I haven't been able to take a closer look at the ledger, so I can't speak to the claim. But we'll look at it and hopefully.
Go ahead, man. What did you want to tell me?
Well, I was in court, this last November for the same case. My son had passed away, so they dismissed the case. But my legal aid attorney that I had asked them to figure out how much was owed because I didn't owe them all of that. I did put in an answer form to the clerk. I have pictures of the repairs that needs to be done and the repairs that, excuse me, that I have done.
Okay, legal services going to represent you at this point, you know?
He's he's out the state this week. He did send me Alex Henry.
Okay, did he say he was going to represent you?
Yes.
Okay, let me do this then. June 27th, 2025, 2 p.m. Okay, get back in contact with Mr. Henry and let's try to get that sorted out where we're going to.
All right, thank you.
Thank you. Strong Future Homes versus Catrice Hadley.
Hanging for plaintiff.
Good afternoon, Your Honor.
Good afternoon. What's your name?
Catrice Hadley.
All right. And what's the claim on this case?
I have a balance including court costs of $2,108.
All right. And the notes from last week said you were going to have it paid in full by next week.
Yes. So I have a check that I'm prepared to endorse to them today for $1,000, and my refund check is supposed to be deposited any minute now.
Refund from
school.
Where are you in school?
Henry Ford College.
I don't know then. All right. What are you studying?
Social work.
We had enough of those. Okay, so you got your refund check coming in. You have $1,000 now.
Yes, sir.
Okay, but I don't know. They can't take a third-party check, probably.
Your Honor, I don't know what the negotiable instruments do anymore. I think probably, since it's gonna be adjourned for 2 weeks, Ms. Hadley, if you could maybe, cash it or.
That's fine.
Okay.
That's fine.
Yeah.
Then here's what I'll do. I'll adjourn it to June 27, 2025 at 2 p.m.
That works for me.
If you get that $1,000 into them and then and your refund comes through, then you get it paid, then you don't need to be here then.
Yes, sir.
All right? Okay.
Works
Thank
for
you.
me.
How are your grades?
Really good.
Really good? Okay.
I'm proud of myself.
You know, when
45 back in
you see
school.
the smile on their face? Oh, yeah.
I'm doing
Fantastic.
great. Thank you.
All right. You take care. Strong Future Homes versus Candace Long.
And for plaintiff, Your Honor, defendant Anthony Long was here earlier. He had to go to work. He says he's going to pay the balance in full on, I think it's Monday. Obviously, that's within the 10-day period. I told him that I would ask the court for a judgment, but we would set it aside if paid in full on or before June 23rd, 2025
All right. So what is the claim?
The balance rent to retain possession is $717. Court costs are $222 for a total of $939. The redemption date is June 23rd, 2025, and it will be set aside if paid in full on or before June 23rd, 2025.
All right. I'll issue a judgment for possession. I'll do it by default. Redemption amount in the amount requested with the writ issue in 10 days. That will be set aside if it's paid. All right. That one. Go back through these. No. What'd you say?
Okay.
Let's see who I want to call. Let me call this one. Strong Future Homes versus O'Day.
Jillian Ingham, plaintiff.
See, I'm gonna make you late.
Good afternoon, Judge Simpson.
Good afternoon. What's your name?
I'm Lolita O'Day.
All right. And what's the claim in this case?
I have a balance including court costs of $909.67.
All right. Ms. O'Day, how are you going to get that paid?
I talked to Hawk and I'm waiting on my SER, but I was just at court. It's $800 and some dollars. Like, I don't know. This is from
It looks like a late fee might have been added.
This is from 2023, Your Honor.
Okay.
I mean, I don't know. They never told me nothing until now that I owed this back money. And I just got to talking to legal.
You don't know it? Or?
I don't know. I can't even remember what I ate in March of 2023, Your Honor.
What you ate in March of 2023?
I don't know.
If you could even remember that far back. Because what was this morning? What did I have this morning? See, that's as far back as I can go.
That's why I'm in court for 2023. I don't know. I just got my ledger from Tanisha. I got all my papers.
Did you want somebody to help you go through that? Did you want to talk to legal services about going through that?
Yes, sir.
All right. So here's what I'll do. Let me adjourn it June 27th, 2025 at 2 p.m. That'd be an in-person hearing. Get with them, go through the ledger. Let's try to figure it out.
Okay. You said June
27th.
At what time?
At 2 p.m.
2 p.m. Thank you, Judge Simpson.
You're welcome. Now you take care.
What'd
you say?
Thank you.
What'd you say?
I said I will. I will take care of it.
Okay. You have a great weekend.
Yes.
All right. Did I make you nervous?
Still true. Yes.
Wow. Oh. You did not have to sign on to what she was saying.
When a person ain't never been through none of this, Simpson, you know, I watch you a lot and you're very, very, very fair. And I love that.
Thank you.
I'm just shaking.
No, I got you. Thank you for saying that. I appreciate that. Turn around and tell her that. Sparrowwood Apartments versus Regina Agnew.
Jillian Egan for.
I was gonna make her wait to the end.
I thank you. God is good. I thank you because I want to go to work. I said, Lord, if you let me be out of here by 1:30, I don't have to call off because I need the money.
You are just gonna hold church up in here, aren't you?
All right.
What's your name?
Regina Agnew.
All right, thank you. All right, what is plaintiff's claim in this case?
I have a balance including court costs of $1,504.90.
All right, Ms. Agnew, how are you intending to get it?
I talked to Robert G earlier, this morning about Tennis, and I went on the portal because he straightened some things out for me where I can go in, and I paid $200.90, which came out to $206.91 because of 2.99%. That's a lot of extra money. $6 is a lot in this economy. But anywho, to make that payment, I had stated to him that on the 20th, I would make a payment again, and I will be all paid up by the 27th. Okay. So on next Friday, I will make a payment of $550 and the remainder on the 27th. Right. Now, what I would like to say is I understand business is business and they need their money. When I moved in the end of March, 6 days before the end of March, my door is, how would you say? I would say jimmied by the maintenance person, the sliding door, where if someone really wanted to get in my home, they could. And if I could just put it in escrow so they know that, okay, I know it's business. You're bringing me to court. Yes, I owe you this. Yes, I do. But please make sure that my living quarters are good per the state guidelines as well. Because they told me that it would take the guy that came out and measured the door.
See,
you can. The gentleman that came out and measured the door said that they had been telling them Empire Management with the prior tenants that lived in that particular unit that I'm in now that they would need to replace the door. And the door has not been replaced yet. And today is, June 13th. Thank God I'm not superstitious. And it has not been replaced. So to be fair,
you need the door replaced.
I need that door replaced. I haven't been holding funds because of that. It's just other things that's been going on. And I just returned back to work on this past Tuesday due to.
What do you do for a living?
I'm in the auto industry, 26 years. Auto industry. Yeah, I know they say, oh, why she in court? So all the not you, Your Honor, but to all the living, because there's some people out here that watch this landlord tenant stuff that don't work and they just want to such and such was in court because they owe for this, but it's real out here. And mental health is real. I have lost people, but I'm saying this for the viewers too.
Oh, so now you better talk. Go ahead, girl. I could not stop you. Just go ahead. I figured she wasn't talking to me, so go ahead.
No, you're good. You're right here. You're right here with me. You're right here with me. You just make me nervous while I have to keep going back to the bathroom while I tell my neighbor. If they call my name, please tell them I just went to the restroom. But I haven't been holding money due to what they owe, but they're coming down hard on me. So since we're going to be hard about it, please take care. You shouldn't even okay for me to move in when I did and things was not taken care of. That's all. That's all I'm saying. But I will have this satisfied by the 27th, and I look forward to seeing you. If I have to come back in here in court, I hope not, because my shift started at 2:30, and I don't have to call in because God is good, because I'll be out of here. But we as people,
you just let me know when you're finished.
So we as people in the auto industry, we go through things too. I just want the viewers to know. Yes, I thank God for my employment. I was able to raise my children up on it, but there is things that goes on in life.
Okay, all right.
Thank you, Your Honor. I appreciate you.
And you. Did you want to say anything, Miss?
Your Honor, I don't know if I can follow that up. Is it the latch? It's just not latching?
It's what it is it's the sliding door. And so, you have the door that latch, but the back side of it is a gap. Rodents can get in, so they put cardboard in it.
I see.
And they told me they ordered the door, it would take 6 weeks. So we're 6+ weeks out. And I just need communications, everything, like they tell me, and I agree.
Thank you.
But I'm not holding rent because of that. But since we in here, let's have a conversation about it. Respectfully.
Okay, did you want, you mentioned, I almost know when.
Escrow.
You want to put it in court escrow?
And I do.
All right, so you need.
Next Friday, I will come to the courthouse and I will put that $550 in. And the following Friday, on the 27th, I will pay the remainder. And I tell you, Your Honor, you will not see me out of good faith in July, because July will be on time.
All right. Thank you, ma'am.
You're welcome.
All right.
I appreciate you. I do.
June 27, 2025, 2 p.m. All right.
Okay. Thank you.
You take care, and they'll make sure to get you to do it. Really? Oh my God. I'm tired now. 12-hour apartments versus Duford. Recall.
Jillian Aiken for plaintiff.
Were they here?
I thought he was.
Okay. This is a recall on the case. They're not here. If you'd like to take a default, you may.
Your Honor, actually, I would like to request leave to amend. We have a 1 month.
Yes.
Split, and I just want to.
Leave to amend. You're amending it to a termination action.
We'll probably include both counts.
Gotcha.
Thank you.
All right. Leave to amend is granted. And I will then adjourn this out, give you time for service to June 27th, 2025.
Thank you, Your Honor.
At 2 p.m. Thank you. That's it for that block. Let's get the video going. And then get the program there. I'll come back. Court is standing recess. Everybody can remain seated.
All right, I'm going to get the 2 o'clock, I'm sorry, the 1 o'clock people to call their names, speak up for me. Sadie Armstrong, are you here? Sade, yes. Sade? Yes, thank you. I'm so sorry. Jordan Oren, are you here? Yes. Thank you. Angela Schmidt. Edward Woods, I'm in Zoom. Quantavia Standrit or Christopher May? Michelle Kresnick, I see you in Zoom. Amy Wisner, here. Thank you. Tamara Hopkins, I have you. Katie Campbell Little, are you here? Thank you. Derek Lanchon, or I see you.
Any info on, but because
let me know when that goes through.
how you doing today, Ms. Ross?
I'm doing well, sir. How are you?
Well, better now that you're here. What would you otherwise be doing on this nice Friday than being back in 8D for a third time on this case?
Probably in some rural circuit somewhere.
Well, you're welcome then.
Some murders.
So Kevin, is it an attachment? Yes, I've sent what I received from the court. It
went in a weird format, but the Zoom should be in there.
It should be clear on him.
What's on the screen now in front of you, Mr. Hort? The little screen.
Same thing as the podium.
Good. there's something wrong. Is your screen still black?
My screen, well, they turned my screen on, so I look at your handsome visage as you described it.
Your words. All right. It's not letting me get into the controller on that one to link it. Ms. Hansberry, any update?
Ms. Tillman's getting into the system now. She just got the new link. Yeah. All right. Thank you.
Okay.
All right.
Here we go. All right, Coffee Correctional, just
Black glove, if it doesn't fit, you must acquit.
Yes.
Okay. Do you have any objection, Mr. Armstrong, providing us with your notes from this case?
what do you mean by notes?
Handwritten notes.
Notes she would have made contemporaneously, Ms. Ross, during the trial, or notes from an interview she might have had with a witness leading up to the trial, or all of it?
All of it for her work product in the case.
Okay.
I filed a motion for discovery, and I would reference that motion. And part of that is that Mr. Armstrong claimed this privilege, but then waived it because he did already provide us at least one note.
He's referring to a Post-it note that is on the back of one of the pieces of discovery that I turned over a year ago.
Was the Post-it note inadvertently included, or you purposefully included the Post-it note?
I included the things that I was turning over to him as they appeared.
Okay, in other words, you didn't modify anything.
I didn't modify anything. I wasn't making any decisions about it.
The Post-it note was attached to what?
Some document from discovery. It was on the back of it.
Okay.
That Post-it note, we've turned that over, so that's out there.
Understood, but the Post-it note was attached to, for example, a police report or something from the crime lab, and there just happened to be a Post-it note attached to it.
I don't remember what it was. It might have been those things like the defendant summary screens, the one that had like 404 or SB 440 listed for Leslie Singleton and not for the other two defendants. I
Okay.
don't remember what it was, but it was attached to one of the documents that was discovered.
A discoverable document. It was not a Post-it note attached to someone's notes, and the page of notes was what was included. Okay, all right.
Paragraph 9 asserts that the note was related to the statement of state witness Rivera. And again, in the discovery provided by Mr. Armstrong to us.
Okay. So we actually have a question on the table that Ms. Ross needs to answer. I just had you clarify what you meant by notes, and it would be notes that Ms. Ross made at any point during her work on the Singleton Waters third guy case.
And does that remain your answer after our discussion, that you have no objection to those notes being provided?
Oh, she didn't answer the question. I interrupted and said, I'm sorry, what do you mean by notes? I didn't let her answer, and I apologize for interrupting, but I didn't want us to wade into, oh, that's not what I thought you meant by notes. But now I know what you meant.
I thought I heard a no. So anyway, the question. Do you have any objection?
Defer to the district attorney's office on what they're going to do on that matter.
Would you agree that these notes, even 24 years later, could be used to help refresh your memory?
Potentially. I have no memory of notes from this case, though. I'm sure I took notes because I take notes. Take notes all the time. But I have no specific memory of notes from this case.
That is a good answer. And let me show you the note. Again, it's attached to our motion for discovery filed May 16. This your handwriting? Here I'm asking a question. I don't per se know the answers.
Right. Hold on a second. That does look like my handwriting, yes.
Any reason why it took 30 seconds to acknowledge it as your handwriting?
Because my handwriting has gotten sloppier over the years.
So you had to rewind 24 years to how nice was my handwriting back in 00?
It looks a lot nicer than than it does now.
Okay.
And sometimes, like me, you need to put your glasses on.
Well, there was that too, but it made it easier too.
I have Ms. Waddell taking notes because my handwriting is so bad. Judge, did you want to rule on it now or wait? What's your thought on our motion?
I'd like you to keep asking questions. You said we were going to defer procedural stuff until after we're done with Ms. Ross, but she has on the record said her answer to the question, does Sheila Ross as an individual and the prosecutor from the case have any objection to the district attorney's office disclosing her notes, her work product? Her answer was, that's a district attorney call. My words, but that I think summarizes what she said.
Yes.
Okay. Next topic.
Thank you. Do you remember the assessment of Leslie Singleton and his family prepared by the Juvenile Department of Justice?
No.
Do you remember Mr. Gishard ever talking to you about this assessment or something similar like that?
No, I don't have memories of mine and Mr. Gishard's conversations about this case outside of court.
Do you know, Mr. Hort, if that assessment was prepared in connection with sentencing, sort of like a pre-sentence report, or if it was simply a report that was available that summarized how Mr. Singleton had done at the youth detention center during the time he was in custody?
Thank you. Yes, and Mr. Armstrong certainly can correct me if he has a different interpretation, but it's my understanding that it was prepared early on in the process. Unfortunately, that report is not available. It's lost, missing, whatever. And the person that wrote that report even knew Mr. Gishard has passed away also.
How do you know the report exists or existed?
When the court helped us actually look at the clerk's file, there was a reference in that file to that report.
Okay, so it's meaning it had been filed into the record?
Well, it was in the file, but as far as I know, it was not on Odyssey or anything like that.
It was in what file?
That file that you helped us
The clerk's file?
Yes.
Okay, so when I said record, I don't mean, unfortunately, something you and I could easily find in Odyssey, but back in the era of this case, it would have been in the clerk's file so that if someone asked for the record of this case and was able to go through the physical file, of which we only have parts now, you think that DJJ report would have been in there?
It was referenced.
Okay.
And then from what we could find out when we actually then contacted the agency, it no longer is in existence after X amount of years. They destroyed the paperwork. And the person that wrote the report, again, she's passed away, so we couldn't talk to her.
Okay.
Because also I want to show you what is marked as defendant's proposed exhibit U. And Mr. Armstrong, let me likewise give you a copy.
I want to go back before we talk about proposed exhibit U. And you're not testifying, but I'm just trying to understand what would have been in, not the substance of it, because it could have said Mr. Singleton is a bad kid or he's a great kid, but what would have been in there? What's the nature of the type of information that would be in a report like that?
As far as I can tell, my belief is that it would have been similar to what we had done 20-some years later, Defendant's Exhibit A, an assessment of Mr. Singleton, his family, the good, the bad, the ups, the downs, that type of thing.
Okay. So it's something of a history of what's gone on in Mr. Singleton's life leading up to him coming into DJJ custody.
Even before that, it's up until when he then was arrested, because I understand it was ordered very early on. I don't think it was per se related to sentencing or anything of that much later on.
Okay.
Okay, back to defendant's proposed exhibit U. It's a report from the Fulton County Police Department provided to the defense by Mr. Armstrong. Does that include a case synopsis of what Debbie Blaylock and her daughter told the police?
Well, I read the first page, but not the second, because then I decided it was probably better to listen to His Honor than to read. So if you want me to read the second page, I will.
If you wouldn't mind, thank you.
They are both mentioned in here, yes.
Thank you. Was Debbie Blaylock's statements in defendant's proposed exhibit U and then also her testimony at trial truthful?
Objection, Your Honor. Why is he asking one witness about whether another witness's testimony is truthful?
So that's generally not where we go with, hey, did you believe this other person? I guess if Blaylock came in here and testified and it was inconsistent with what Ms. Ross was saying, I'd need to figure something out about that. But did you, maybe you mean to ask it in a different way, and I'm not putting words in your mouth, but is Ms. Blaylock someone who testified at trial?
Yes.
And was the question more, does this report, is it consistent with her testimony at trial? Or, because commenting on the veracity of someone, that's not what we typically have witnesses do. I didn't believe that person. That's not relevant.
One, she was the prosecutor. Two, Debbie Blaylock was one of their main witnesses because she also was a victim in this case. And two, we already had testimony from this witness that she believes Waters' testimony was truthful. So my follow-up question, what about this witness? Was her testimony, her statements truthful? And I think she can offer that opinion. One, again, as the ADA in that case, was there, you were not, the rest of us was not. So I think it's an appropriate opinion from this person.
Okay, Mr. Armstrong, anything else you want to say in particular in connection with, I'm not remembering it, I trust it happened, that we've already had an exchange about Ms. Ross's view of the veracity of Mr. Waters's testimony?
The fact that the defense has already asked her to comment on other witnesses' veracity doesn't make it any more relevant for a second witness.
Okay.
Ms. Blaylock testified at trial in the state, is absolutely relying in part on her testimony.
Okay.
But if there's a specific detail or something like that, that's really important to note. I think that that's something that if there's a record, it's the record that's going to speak to the difference. And I don't think just randomly asking people, was this witness truthful? Was that witness truthful? That doesn't seem relevant to anything that I'm aware of before the court.
Okay. I don't think it's a random request, but I agree on the relevance piece. Mr. Hort, if there's something in the document that Ms. Ross has in front of her that you want to ask about, as in her report, she says it was dark out, but at trial, she didn't testify that it was dark, or she said it was light or something different, we can explore that. But I'll sustain the objection as to the generic and summary assessment of, yes, I believed her or she was truthful.
Let me try this first. We would move to have admitted into evidence defendant's proposed Exhibit U, which again is the case synopsis of the testimony statements given to the police department by Ms. Blaylock and also by her daughter.
Any objection of Mr. Armstrong to the admission of defense U for purposes of this hearing?
Yes, Your Honor. It appears to just be 2 pages of a longer document. And so I would submit that the whole document we don't have an objection to as far as being part of discovery. Coming in from the truth of the matter asserted, that's a different thing. We object to that. But as far as showing what was in discovery, we don't. But we would like the actual full synopsis as opposed to an excerpt.
Okay. I know, Mr. Hort, sometimes you give us everything you've got, and you may only have 2 pages from a larger document, which highlights another issue 25 years later. Do you have the whole document? And if so, is there a reason why we're only working with a few pages? Or is Mr. Armstrong misreading this? And that, in fact, at the very bottom of the second page, it says end.
Yes, I do have the whole document, and for some reason, I kind of guessed Mr. Armstrong would make this objection. So I do have that whole document. My purpose in just doing U was to what Ms. Blaylock said and what her daughter said.
Okay.
But the rest of it not necessarily being something this court needs to know. But again, if that's the preference, I can certainly.
But I heard Mr. Armstrong's objection being a little different. I noticed what you held up, like has a photograph on it, for example, and that may well be Sergeant Grigley. But what Mr. Armstrong said to me was there's more to her statement. In other words, there's a page 3 or a page 4. And so my question to you is, why wouldn't we put in the entirety of her statement, because I'm hearing there's no objection to that insofar as it's being tendered as a subset of the discovery in this case. So I would ask that the entire statement go in. I don't know that I need that cover sheet that has the photograph unless that has more of the summary of her statement. And you said it was her daughter's statement?
Yes.
Okay.
So in addition to what I offered in talking so far as the daughter's statement, the defendant's proposed Exhibit U ends with, and she stated that they were on. The next page goes, the phone. She ran to his side and tried to comfort him. About this time, the Fulton County Police units started to arrive.
Okay, but that's someone, I guess, recounting what she remembers about the situation.
Yes, but not what happened. So this is post what happened.
Okay. Is there a reason you don't want me to see post what happened?
I just didn't think that was relevant. I certainly didn't have no objection.
Okay, then let's make you, Exhibit U, the full statement that she and her daughter gave. No?
So do you?
Well, what I'm reading is a summary, and it says in it that she will be taken down to the office for a more formal interview. So just so that we're clear, U is a synopsis there would have been formal interviews of both Ms. Jeter and Ms. Blaylock, which are not part of this synopsis summary that are these 2 pages.
Okay, I remember Mr. Hort saying this is a summary, so this isn't the end all and be all. He wants to get into evidence. Mr. Armstrong is saying no objection as long as the whole document comes in. So show Mr. Armstrong all of what big U would be, see if he has an objection, and if he doesn't, let's call that U and we can press on.
I'm sorry, you do.
I do. We're good. I have the equipment was moving, but we couldn't hear you cheering.
Okay. Judge, this next part goes to the Lomax case. It goes to the sufficiency and reasonableness of the inspection.
All right. Before you press play, I see some customers sitting there. Do we know which, if any of them, we have 2 affidavits. I don't remember the names of the customers.
My understanding from the 30B6 deposition is the man with the iPad is the one who gave an affidavit as a customer.
Okay, got it. Ready.
Okay. The Ms. Marquez falls in about 2 minutes, and the inspection cited in the motion is coming up here in the next few seconds.
Are those the pictures that Toronto English sent you?
Some of them, I didn't get too many.
Okay. But she did send you some pictures.
Yes. Mhm.
And what did you do with the pictures?
I had them in my phone. I thought I had downloaded them, but unfortunately, I only have the picture of Treasure, of her laying on the futon.
Is Miss Taylor out there? Okay.
She said that he was locked in a room. The oldest boy, is Taiwan the oldest, the 5-year-old.
This was the inspection, Judge.
Baby boy was on a 5-year-old.
This was the inspection, Judge.
Baby boy was on a couch somewhere in the living room, I think.
And Judge, we're arguing she didn't even look at the floor. She was doing something over to the side with a tray, putting something up. It wasn't an inspection of the floor at all.
Taranya said that he needed pull-ups for the children.
Can you rewind it a little bit? I saw what she did, but then I want to see how many people walk through this area. And I couldn't tell if that gentleman with the dark jacket, so that guy I saw walk through.
Yes, sir. There's a few fire EMTs and firemen there actually eating breakfast. He did walk through the area.
Yeah, but there was okay, we're good. Keep it playing.
Yep, and go to the store and then come right out. Because neither one of them was doing any big shopping.
Just what's coming up is the inspection that, as a matter of law, according to the defense, was a reasonableness inspection, that there's nothing on the floor and that plaintiff cannot even get to a jury on the issue of inspection. That is what the argument is.
No, I understand what the argument is.
Taranya asked him, and he said, just worry about your own kids or something like that, he said. Or worry about your own daughter.
Once you receive those pictures, did you contact me that?
Yes, I did.
Don't stop it yet. I want to see. Okay, he comes around the corner there. All right, thank you.
About the child being locked in the room.
Now I'm going to just, to expedite things, I'm going to bump it forward. This guy walks through there too, Judge.
In the house, it concerned me very
deeply. Guy with camo on.
Felt like
And then here's Ms. Neal walking through again. And this,
the condition they were living in, and
how there's also, that's not an inspection either, is our argument. None of this is an inspection.
He cursed her out.
And then plaintiff is getting ready to walk through. Plaintiff is right here, Judge, at the top of the screen.
With the black sweatshirt?
Yes, Your Honor.
Okay.
Yes. Yeah. Basically the same thing that I told the courts, that
that I had asked, was
In the white spaghetti straps, that's Maria Marquez, the witness who testified about the ground being wet. In a minute, you'll see her move her shoes. She testifies in her deposition that she was moving her shoes to show that the ground was wet, to show the fireman that the ground was wet. She testified in her deposition. That's what she was doing, was showing that the ground was wet and slippery.
I pick it up and give it to her. And it was like, that was it. She didn't eat, and the other two boys gobbled theirs down. She
was fortunate to have about 19 firemen on scene to attend to her.
Yes, she was. Yes, she was. Now, Judge, I want to, the reason that I say that we want to argue the Lomax case, that the inspection was not reasonable, is because there is a video of a Big Wake employee doing an inspection of the area after the fall. And it is at approximately 9:48.
The kids were taken from the.
And I'm going to play that for you.
Ms. Taylor, don't go too far, please. Okay. She's here.
I know it's here.
Yes.
Okay, in a second, a woman in a gray shirt is going to come and do.
And they went to the house.
And actually look down at the floor. You can see her looking down at the floor on the right there. She's carrying a tray. Now she's going to stop when she walks halfway back and look down at the floor.
My daughter did, but she was at work. So she asked me, can she bring the kids to me until she got off work? And I said, that would be fine.
See, she's looking down at the floor right there.
Yes.
Now she's also going to come back and look at the floor again after she drops off the tray.
There's a white and red bucket that people have touched and moved around, and employees have. Do we know what that white and red bucket is?
That's a cleaning station. They use that for cleaning, for like bussing the tables and things like that.
Yes.
So that white and red bucket could be full of a soapy liquid?
And when I was giving dinner, then you, and she took
If you rewind a little bit, there was another employee who was at that station doing pretty much what Ms. Neal was doing, not looking at the floor, but putting a tray down, and that thing right there, so it just reappeared. See that?
That's not a mop bucket.
They can walk, but they
It's not a mop bucket. It's
But
like
if you dump that out, would dust come out of it, or food, or would a soapy liquid come out of it?
walking okay.
We don't know.
But the two oldest ones walk like,
the 30B6 deposition, Judge. They testified that it's a bucket that they keep, like that they use to bus tables and use like to wipe down tables with. He wasn't clear as to whether it was a like sloshing water or just if it held.
Okay.
They made sound, like they wanted.
What I want to show to the court, though, is what an inspection of the floor looks like when someone, because right now, this person in the gray is going to look at the floor, point at it, and then instruct someone to go get a yellow wet floor sign.
That they were.
And to get out in front of it, this is not a subsequent remedial measure because the defendant denies the floor was wet.
Based on what I've witnessed in 36 years, no.
So it's used to show the defendant is incorrect about the floor. It's an impeachment evidence. And it's also to impeach the defendant on what an inspection looks like. This is a floor inspection right here. That's a floor inspection.
They weren't even,
That's a floor inspection.
play with toys or.
At 4902 End Exhibit D. That's a floor inspection. And in a minute, she's going to come back and put a wet floor sign down where plaintiff slipped.
Ran around and picked up toys and put them down, and I took them out to play. Basically, just ran around.
Did you observe any bruises on them?
No.
And Judge, as soon as she does that, I have about 2 more minutes of legal argument and I'll be done.
Okay.
But thank you for coming in. Ma'am, you are officially excused. You get to leave the building or you can remain in the courtroom. It's your choice.
Okay.
Okay, I'm going to stop sharing my screen. That was at about 50:40. She puts the employee in the black sweater puts a wet floor sign down in front of the workstation where plaintiff fell. Judge, I want to point your attention to a case called Pipkin versus Azalea Land Nursing Home. This is a 2016 case. And this case illustrates the difference between circumstantial evidence that would allow an inference versus mere conjecture. In this case, the Court of Appeals emphasizes the difference in what the plaintiff needs to know versus summary judgment. Okay, and in this case, the court cites a number of cases, Smith versus Tenant Health System, where a janitor wiping down a cart prior to a fall and a witness saying that the floor was wet was sufficient to survive summary judgment, where the defendant contended the floor wasn't wet and it was mere conjecture. Neither is our argument. I'm getting ready to walk.
Yes. Yeah. Yes. Yeah. Basically the same thing that I told the court. Basically the same thing that I told the court, that I had asked, with
in the white spaghetti straps, that's Maria.
To guessing what Ms. Marquez Adame fell on. She has not put forth proof or evidence of what it is that she fell on. So her sister claims wetness. Petras claims it looked wet. Maybe it was grease. I don't really know. That is the exact textbook pure conjecture that is referenced and on point with this case in the cases that are cited in our brief and that the Court of Appeals has repeatedly held. If you cannot put forward proof of what the hazardous substance is, you cannot establish causation, and which is an essential element of negligence.
But you don't mean that Ms. Marquez Adame has to say, I know it was Dr. Pepper. Not only was it a brown liquid, but it was Dr. Pepper. I slipped on Dr. Pepper.
Right, correct. But here it's, was it green? Was it water? Was it greasy? Was it wetness? When the witnesses were asked, what was the size of it? What was it shiny? They said, I don't know. I wasn't paying attention. I wasn't looking at the floor. I just know it didn't look right. It was wet. And that's all that they can get. It cannot describe with any particularity.
Well, I look at Pipkin, the language that was on the screen looked like it gets us into that space that we're arguing over.
And then plaintiff just cited a case that is not cited in her opposition brief, that Pipkin versus the nursing home case, the 339 Georgia Appellate 390.
Yeah.
I haven't had the chance to read it. If the court would allow us the opportunity to just do a brief briefing on that, we would appreciate that. But what I could tell, at least just from the brief overview that plaintiff had up on the screen, it looked like there was a cart and mop bucket around possibly. Again, there is a source then of the wetness.
I noticed that there was an additional element.
Separate, which is not the case here.
Okay.
With respect to the claim that the inspection was negligently done. It was a non-inspection of the area. The law says that a reasonable inspection has to be done. This body of law, premises liability law, is all about reasonableness. Reasonable inspections, giving the defendant a reasonable opportunity to inspect and remove the hazard, giving it a reasonable amount of time. It is not reasonable, and the courts have never held that it is reasonable for an inspection for employees to have to shuffle around an entire store with their head down, analyzing every single tile of the floor. In all of the cases cited that I discussed today in our brief, the Court of Appeals held that where an inspection was done within that 30-minute time frame, so one case was 5 minutes, one was about 5 to 10, I believe, and one was 15 to 20 minutes, whether it was a manager, whether it was an employee, whether it was a security guard, all of those folks testified that during that time frame, they did the inspection and they found no hazardous substance on the floor, and that is on all fours with exactly what Ms. Neal testified.
I want to make sure, though, that I'm not going to pin you down to something that you're saying, wait, that's not what we're saying. Exhibit D, we watched, and there was a point in time when Ms. Neal was at that cleaning station, and Mr. Cawthorn said, this is what Big Wake is claiming was the inspection. Is he correct that point in time when Ms. Neal shows up, she puts some trays down at that cleaning station and is present at the cleaning station, and it's just a few moments before Ms. Marquez Adame walks by and slips and falls, although a few people pass through there after that. That's what you're calling the inspection?
She comes through twice. She comes through first. She walks towards the, they call that a kiosk, that little station. She comes towards it at about 9:02 and she puts the trays away. Then she comes through again. But yes, that first time, when she is, actually, I believe it's the second. It's when what's cited in our brief, if Wick wants to pull back up the video so that we can talk about time exactly. I know you're running out of time, Judge. But what's cited in the brief is that it's at 9:03:41. And that's when the plaintiff is also seen walking in. You can see Ms. Neal and the plaintiff in the same frame. Ms. Neal walks directly towards the area. Her head is facing towards the area of the fall, and then she is at the kiosk and then turns around and walks kind of in the direction of where those booths are at.
I don't remember the timestamp, but Mr. Cawthorn played several times what he said, this is what Big Wake says was the inspection. And I'm remembering specifically what Ms. Neal did and didn't do in that segment. I just want to make sure you are agreeing that that's what Big Wake is labeling the inspection. Because if you feel like there wasn't a segment he played, I guess the other thing is you guys can get me Exhibit D, so I can watch it. But
yeah, I don't want to speak incorrectly on the record because I don't know what the timestamp was on that of what he was referencing. But the timestamp of when she identified herself on the video at 9:03 a.m. Is when she's approaching the hostess stand and the plaintiff is behind her, and she testified that she moved around the restaurant. She was making sure that all areas, including the floor, were clean for the guests. And if she had noticed anything, she would have cleaned it up immediately. She identified herself in the surveillance video footage at 9:03 and recalls that at that time she saw nothing on the floor.
okay, Mr. Cawthorn, put that back up, please, Exhibit D. I don't want us to leave and then later on Big Wake says, no, that you looked at the wrong thing. That wasn't what we call an inspection.
I'm pulling it up.
Thank you.
Let's see, share.
Deputy Gordon, what time is it really? This clock and the clock on my computer are 8 minutes apart. 10:56. All right, so +1. All right.
30. Okay, I think this is the one where.
All right, this is 9:03. Okay, so rewind okay, great. Play, please.
This is the last one, the second one. We played this one. Because that's where plaintiff is right there.
The area.
Okay, got it.
Okay.
What else?
Judge, do you want me to leave it up, Ms. Wharton, or do you want me to?
No, you can take it down. Thank you.
Thank you, Rick. I appreciate it. So under Georgia law case precedent, an inspection like that, where the witnesses testified that they did an inspection, that they did not identify a hazardous substance on the floor that was within that 30-minute time frame, has been found adequate as a matter of law. The linchpin of plaintiff's cases, did Big Wave have superior knowledge of an alleged hazard? And the answer is no. She cannot carry her burden of proof there. And then with respect to the inspection after the fall, the 9:48 a.m. when the wet floor sign, that happened so far after the
You don't need to address that.
accident. So many people walk over the area, the firefighters. I'm sure we'd have to examine the video, but I don't know what people had in their hands. And
It just, to me, it's an example of what Mr. Cawthorn is saying. This is what an inspection ought to look like. And so he's contrasting it to what Ms. Neal did or didn't do in the segment we just watched for the third time. But I'm not going to get hung up on, oh, look, there's proof that there was water on the ground. So many intervening events happen that it would be too much of a stretch to say it's the same, whatever it was that Ms. Marquez Adame may have slipped on.
That's Judge. That's all right. That was intended to show that we've got evidence to show a jury to contrast what an inspection looks like.
Got it.
right, but the Court of Appeals has never held that an inspection, a reasonable inspection, includes shuffling around on the floor and examining every tile of the floor.
Okay.
So again, this case is on all fours with prior precedent. It's important to note too that plaintiff had the opportunity to cross-examine Ms. Neal about her inspection and didn't ask any of these specific questions. Plaintiff had the opportunity to do that and didn't ask about the inspection. So I want to make sure that that's part of the record.
Okay.
And to plaintiff's notion that the video should go to the jury because the defendant's interpretation of the video is not what's sufficient. It should be the jury's interpretation of the video. I mean, Ms. Neal testified that she did an inspection that day. I mean, it's not a matter of whether or not, we have.
But if there is, I'm gonna push back a little because you said you weren't gonna talk so much. Ms. Neal has made a record and she's testified to certain things. Mr. Cawthorn has presented video evidence that he says isn't entirely consistent with that, or at least it would give a fact finder an opportunity to make its own independent conclusion. Well, what does inspection mean? And standing in and around the kiosk might be different in a fact finder's mind than what an inspection means to Ms. Neal. So I hear you what's in her deposition, but the total record available right now is not only deposition testimony, but and affidavits from 2 customers, but also video testimony where a fact finder can see collectively for itself, if it's a jury, if it's a bench trial, the judge, this is what the thing labeled an inspection consisted of. And so a fact finder on its own can decide, did she look down? Did she not? Did she look in the direction of the spill? Did she not? What was involved with that? And it can be contrasted with another example of an employee doing what that person might say was an inspection, all of which is in the record right now that I have to navigate.
And with respect to those affidavits, I know you were asking, we saw those 2, the man in the booth. The man in the booth that's without the woman was Greg Anderson, who made the affidavit.
Mm-hmm.
And then the man that was with the woman, the older couple, that was Walter Brown.
Got it.
So that's both of those affidavits. They were sitting right next to them when the fall occurred.
Okay.
And they both in their affidavits said that they did not see anything on the floor before or after. So again, I just want to thank the board so much for letting us do this again. We understand that things happen.
No, but I appreciate now why you all wanted to have a hearing too, because the briefs are helpful, but to engage and see some of the footage addresses both did Ms. Neal spill and was it an inspection? And seeing those videos was very helpful. Okay. All right. Mr. Cawthorn, anything procedurally?
No, sir. I'm gonna work with the clerk's office to make sure that we get all of because the depot exhibits from the 30B6 into the record, which are what was used today.
Okay. Good. I apologize that we muted you briefly. It wasn't because we were tired of hearing from you. That wasn't it at all. There was a technical hiccup and then I clicked on the wrong thing. I may reach out to both of you if I want the videos to watch again. And I know they'll probably come from Mr. Cawthorn, but I won't ever just reach out to him. I'd reach out to lawyers on both sides. And similarly, I may reach out to both of you if I want one side to prepare a proposed order. The other side will, of course, get a chance to preview that. It wouldn't be to rebut it. It would just be to make sure that there's not a misstatement of, hey, that's not what I said in court, or that's not an accurate recitation of X, but not a, hey, I disagree with your legal analysis. Because if I do send out that email, it would be side X. I think you've got the better argument, so get me a proposed order saying motion granted, motion denied. Okay? But I will prioritize this given that this is your second time through this process. Ms. Wharton, anything else?
Thank you so much. We appreciate it.
Mr. Cawthorn?
No, sir, I appreciate it. Thank you for your time.
All right, you guys have a great weekend.
Thank you so much. You too. Bye bye.
Bye.
Ms. Nelson or Ms. Anyone else who's on the call, do I keep this going or do I cancel this and open up a different one?
You keep this one going right now, Judge. It's a different one.
Okay, great. We have a few minutes to get started with the plea, and then we have to pause, and then we'll finish the plea. But I have the chief judge coming. That was supposed to be at 11. I held him off a little bit because this took longer. So we might as well get started, and then we're going to take a quick break, and then we'll finish it. So if you will, I need the 2 case numbers, please. You guys should come up to the podium, Ms. Taylor and client, and I need to add the witness.
And then I have the case numbers for you.
Okay.
I've got 11 o'clock. 1A.
I'll manage 1A for you.
Thank you.
I just see a motion for a new trial now. Is that?
It's happening this afternoon. It was supposed to start at 10 this morning, but we moved it so we could do that motion for summary judgment and this situation.
Non-conference was hard to know who you did. Yeah, I tried to ask him, you know.
Yeah.
Which judge do you?
I went up to 6A and it's to 6 to court administrator. They said 1A Brandon Brooks.
Okay, that'd be valid.
It's what it's supposed to be. They got digital boards outside the door, but what they said coherence to that. Well, honestly, it just takes for time. Until the courtroom, the judge notices. One day they're gonna get that together.
All right. I need those 2 case numbers.
23 SC 191437.
Yep.
The second's 24 SC 004271.
And we're going forward on both?
Yes, Judge.